Good morning, everyone, and welcome to this hearing session, which forms part of the examination of the Bayborough and Mid Suffolk Joint Local Plan. If you can't hear me, please can you let the programme officer know as soon as possible. My name is Alison Partington, and I am one of the two inspectors appointed by the Secretary of State to conduct this examination and to report to the Council in due course. Before we make a start to today's discussion, there are a number of housekeeping points that I need to run through. Firstly, to avoid disruption to the proceedings, can I ask everyone to ensure that their mobile phones and laptops are turned to silent whilst the hearings are in session? As you are aware, the sessions are now all taking place virtually using Microsoft Teams. Everyone should by now have received guidance on attending the event from the programme officer, and the guidance is also available on the examination website. I won't repeat all of that now, but there are a number of key points that I must make people aware of. You should be aware that the proceedings are being live streamed to YouTube in order for the general public to observe them. Anyone who makes their own recording of the hearing sessions or any part of them should ensure that they comply with the law in terms of any distribution they make of that recording. Today's session is covering matter 6, which deals with economic, retail and tourism policies. The format of the session is that of a structured discussion, which I shall lead. Whilst the discussion will be based on the matters and questions that I have identified for this topic, there are some issues on which I need no further information beyond that which I've already received in writing, and on which there will therefore be little or no discussion. On others, I will have a number of supplementary questions based on the contents of the statements that I've received. All previously submitted written evidence is to be taken as read and need not be repeated at length. I am not expecting that any new or additional material will be tabled at the hearings, as the aim is for everything to be made available upfront to everyone so that we can have a useful discussion. If you wish to refer me to documents within the examination library, please can you make sure that you give the document reference number as well as its title. When you are not speaking, please can you make sure your microphone is on mute. Given the number of participants, whilst the discussion is ongoing, you may wish to switch your camera off when not speaking, although it would be helpful to me if the main council witnesses would keep their cameras on. If you would like to contribute to the discussion, then please use the raised hand function. When I invite you to speak, remember to unmute your microphone and put your camera on, remembering to mute it afterwards and take down your raised hand. I will invite participants to speak in an order which I consider is best to assist me, so please be patient if I don't come to you immediately. Please say what you need to say when given the opportunity, and make your contributions brief, focused and relevant to the questions I have asked. There is no need to repeat what other people have already said. Can I remind you also that there is to be no use of the screen sharing function. I would ask everyone to be patient, as some people may be less used to using technology and so may find getting to grips with it more difficult than others. Each session will be about 90 minutes in length, so this morning the sessions will run from 9:30 till around 11, from 11:30 till around 1, and the afternoon session will be from 2 till around 3:30. I'd like now to ask each of the participants to introduce themselves. Firstly, for the council, please.
Morning, Madam. My name is Michael Bedford, Queen's Counsel. I'm a barrister instructed by the two councils to provide legal support for them during the course of the examination. And today, I think principally you'll be hearing from Mrs. Jennifer Candler, a Senior Strategic Planner, and Mr. Dan Malloy, also a Senior Strategic Planner. And it may be necessary to hear from Mr. Hobbs, the Corporate Manager Strategic Planning, who you heard from yesterday, but I suspect it would be more likely to be Mrs. Candler and Mr. Malloy for most issues. Thank you.
Thank you. Then taking the representatives in alphabetical order. From Amber REI.
Good morning again, ma'am. Ben Cook from Pegasus Group representing Amber REI.
Thank you. Artisan Planning.
Good morning. Leslie Short from Artisan Planning representing several landowners.
Thank you. You look like you've got a very exotic background there.
Yeah, unfortunately, it's just background.
Sadly. Thank you. Chiltern Parish Council.
Good morning, Madam. I'm Chair of Chiltern Parish Council representing them, and I'm also in a personal capacity as well, but both positions are pretty much aligned, and I will differentiate if we're at a position of differentiation of views.
Thank you. Is Bergholt Parish Council?
Inspector, they've yet to join the meeting. I have chased them. If they do wish to join, are you content for me to let them in?
Yes, you can do, yes.
Thank you.
The East of England Co-op.
Morning, madam. Yes, I'm Matt Clark from Boyer Planning, and I'm representing the East of England Cooperative Society.
Thank you. GP Planning.
Good morning, madam. I'm Maureen Derry from GP Planning. I'm representing Building Partnerships Limited and Poplar Holdings. I'm also joined by two colleagues this morning, Mr. Paul Knowles from Building Partnerships and Mr. Chris Moody from Savills.
Thank you very much. For Pigeon.
Good morning, madam. I'm here, Nicola Travisili from Turley, and I'm representing Pigeon Investment Management Limited. I'm also joined by Andrew Phillimore from Pigeon.
Thank you. Sproughton Parish Council.
Good morning, Madam Chair. Helen Davis from Sproughton Parish Council.
Thank you. And finally, Stradbroke Parish Council.
Good morning, I'm Odile Vladon. I'm the clerk at Stradbroke Parish Council.
Thank you very much. Does anyone have any questions on the procedural aspects of the session, or are there any housekeeping points that the LPA or programme officer need to raise with me? If not, then we will now start the discussion. I propose what we'll do is we'll look at the employment policies to start off with. So we'll look at SPO 5 and LP 12 and 13 first, before then going on to the retail policies and then the tourism policies. But before I look specifically at SPO 5, I would like to address the kind of first question I raised about that the plan being sufficiently clear as to the need for employment land over the plan period. Now, the council, you've referred me to paragraphs 914 to 918. You also highlight that the OAN for employment land is set out in table 3.7 of ECO 3. I do think the plan needs to contain that information on the objectively assessed need. Paragraphs 9 to 14 say there's only a modest amount needed, but it doesn't actually say how much. And I do think it is important that the plan specifies what that objectively assessed need is. So that will need to be addressed. But also, I mean, in those paragraphs, you talk about there being a qualitative need as well as the quantitative need. Can you provide me with any indication of what that qualitative need is? I'm struggling to understand how much, how how much land you're talking about, and also how much land you actually allocate to address that need. But if you could start off with, at least, can you, is there any indication of what this qualitative need is that you need, as well as the quantitative need?
Madam, thank you. Perhaps if I start, and then I'll bring in Mrs. Candler for any additional comments. As you've rightly recognised, that when one looks at employment land in a quantitative sense, as it is assessed in the Ipswich Economic Area Sector Needs Assessment, that's document EC03, the amounts of land purely in terms of hectareage are relatively modest as they're described. But there are qualitative issues to the provision of employment land, which don't, because they're qualitative issues, they don't readily lend themselves to being converted to a quantitative figure, because what's important is not so much the figure itself in terms of any particular number of hectares, but the range of sites which are available to meet the needs. And that range is both geographic in terms of a spatial spread across relevant parts of the district with a focus on the transport corridors, but it's also qualitative in terms of the sites, different sizes, different attributes, different characteristics, so that there is a portfolio which provides for the diverse needs of the two districts over the plan period. And so we haven't sought to express that quantum in numeric terms, because in a sense the quantum doesn't matter per se as to what it actually is in terms of hectares. What matters is what is the quality of the sites in the supply, both in terms of where they are, the geographic spread, and in terms of their own particular characteristics, in terms of suitability for particular types of employment uses. I can see that obviously then creates more of a challenge in terms of assessing the adequacy of the supply, because the benchmark for whether it's adequate isn't, well, how many hectares is it? The benchmark for the adequacy is to look at the qualitative factors, including, I say, that geographic spread and the nature of the sites. And then there is a judgment which is applied having regard effectively to the different component characteristics of that portfolio, which has led the council to conclude that what has been provided for is a sufficient range. But I say it doesn't readily lend itself to expression in numerical terms. Having said all of that, obviously, if you as examining inspector consider that we ought to articulate, as it were, the totality simply in numeric terms, so that what is in that range at the moment is then expressed, obviously that's something that we could look at. But so what we're trying to avoid doing is using merely that numeric expression as a test of whether the supply is adequate, because it's the qualitative factors that tell you whether it's adequate rather than the numeric factors. So that's in a sense the thinking, but I say we're certainly open to, if we can make it clearer, then obviously we're happy to look at doing that. So perhaps I'll just bring in Mrs. Candler to comment on anything further as to, in a sense, why we consider that approach is appropriate, and what are those qualitative factors that are so important to ensuring that there is an adequate supply.
Thank you and good morning. In terms of the evidence underpinning the land supply, we've got a mix and type of sites by location, and there's evidence which illustrates that effectively in ECO3, and I'd refer you to figures 2.8 and 2.11 within that document. ECO3 is our Ipswich Economic Area Sectoral Needs Assessment, and what that shows is quite clearly is a distribution of sites by clusters of employment and also by sectors, because different types of sectors obviously have different economic demands and require a whole range of sites. And that's illustrated clearly. You can see both the mix in terms of the geographical spread across the district, where there's wide-ranging demand, and also concentrations of some sectors along the transportation corridors and within some of the well-established strategic employment sites, which I'm sure we'll come on to. We also have other evidence in terms of our qualitative requirements set out in ECO2, and that's based on survey information. ECO2 is another sectoral needs assessment, I should say, sorry. And that's based on survey information for businesses. The information specific to Bieber and Mid Suffolk is set out on pages 81 and 82 of that document, but the wider information across the whole of the Ipswich economic area in terms of the types of quality of sites required is also of relevance. And factors which we're aware people are looking for in terms of that quality is, of course, that mix and type of sites, and dependent on sector it will vary, but there are commonalities such as good connectivity to infrastructure, be that digital infrastructure as well as our transportation infrastructure, as well as the cost of premises available and the size of premises, on-site parking, etc. So it does vary, but there's a lot of information underpinning the different qualitative factors which businesses are looking for. Importantly, the study also identifies the types of sites which businesses would want should they be looking to expand or relocate. The study makes it clear that a lot of our businesses, when they are looking to expand, and it was between 70 and 80% of those surveyed within that, are looking to do so and retain within the local area. And there are distinctive factors they'd be looking at when they're doing so, and that is good access to the transportation corridors and fit for purpose premises. That fit for purpose, again, will depend upon the types of sectors, which brings us back to having that spread and different sites suitable for different needs. And it's the in combination element of that which we're looking at to help underpin our strategy, as we say, as well as the quantity itself in terms of the requirement in hectareage. We're seeking to try and accommodate that wide-ranging demand which comes out of the studies in terms of the qualitative from a lot of the businesses who are operating in the area, and also to be able to attract new businesses to the area.
And thank you for that. That's very helpful. Can I understand too some idea of how much has actually been allocated? Because I know there's a number of allocations in part 3 of the plan. I think there's 3 specific employment allocations, and then about 5 mixed-use allocations that include employment of very different sizes. But can I just, so for example, if I take Eye Airfield, where it says there's 64 hectares, is that 64 hectares of land being allocated that's new land, or is, because when I went out to Eye Airfield when we were down in June, it looked like quite a lot of that had already been developed, and not particularly just in the last couple of years in the plan period. It looked a fairly well established employment area. So is that 64 hectares of new land at Eye Airfield, or is that, and similarly like at the sugar beet factory where it says it's 50 hectares, and because obviously in those 3, I think in the 3 employment allocations, straight employment allocations, there's kind of like, it says there's around 130 hectares, which is obviously considerably more than what you're saying is the quantitative need, and is even taking allowance of some the qualitative, and then there's the mixed use allocations as well. So that's what I'm trying to understand, how much land is actually allocated in comparison to what you're saying is the need, kind of thing.
Mr. Malloy is perhaps best placed to answer the specific questions dealing with the circumstances at Airfield and at the sugar beet factory at Stowmarket.
Yes, thank you, and good morning. Yeah, so in terms of the sites identified in SBO5, there is, you're correct, a bit of an overlap there in terms of sites that are existing and have been historically used for a number of years. That's predominantly the makeup of the sites identified under SBO5. But there are some that are essentially new allocations and not under existing uses. So there is a bit of an overlap, particularly in Airfield, in that, so there's almost a double allocation as such. So under SBO5, the total area is about 140 hectares. Now that includes the existing uses. As you'll be aware from your site visit, a lot of those have been used for a number of years. Then the site allocation LA099 identifies as 64 hectares. Now that is essentially trying to address the sort of net, I suppose, within that site allocation. So they're and again, particularly with sugar beet site as well, it's this thing of a number of years since the base date of the plan. So with the sugar beet factory, again, another historic use at the time of the base date of the plan. It would have been a redundant employment site with sort of 2 old sugar silos on there. But things have progressed with that site. So yes, if you'd have been on site now, there's certainly 2 very large employment schemes on there. So the site allocation, which has the hectareage in the back in the sort of place 3 section, that deals with essentially the new land compared to where we were at the base date of the plan.
Right, so basically there is 50 hectares there that is available and is allocated, is new land to meet the kind of need, as opposed to taking off what's already existing, and 64 at Airfield, so that's new. So there is. So what you're saying is that the amount of land that's being allocated is significantly greater than the needs. So that takes in the qualitative need as well. So that kind of qualitative need is provided. The excess is that kind of picks up that and provides the flexibility. And right, that's very helpful to in helping me to understand that. And now,
okay, sorry, Madam, could I just say that in terms of, I don't think we would say that the amount in the supply is significantly greater than the need when you have regard to the qualitative factors. It's certainly greater than the need when you purely have regard to an arithmetic quantitative exercise. But as I say, I think we are, for the reasons already rehearsed by Mrs. Candler, we are keen to maintain that range of supply. So I don't think we would say that the range that we are currently maintaining is significantly greater than the need when you have regard to the qualitative factors. So there's just a slightly subtle distinction, but as I say, I wouldn't want anybody else that's listening to go away with the impression that the council accepts that its employment provision is significantly greater than the needs when you have regard to those qualitative factors.
Yes, yeah, no, I appreciate that. It's providing the flexibility that you think is necessary for the because of the qualitative issues as well as the quantitative.
That's a very helpful and fair way of putting the position. Yes, thank you, Madam.
Yeah. Stradbroke Parish Council, I see you want to. You've got your hand up.
Yeah, I'm sorry to interrupt you. That has actually answered a question that's been perplexing us for some time, how much of Airfield is being proposed. However, the map on page 385 of the submitted plan, which refers to LA099, actually has the entire area hatched. So that's what's been confusing us, and therefore we're not sure which part of that site is being allocated and which part isn't. because the map shows the entire 140 acres allocated.
Right.
So that's what's been perplexing us, because we were concerned about how much more. Is it 64 plus 64 plus 64? We didn't know. So the map needs to be, and it's also on the when you click on it on the interactive map, it shows up as 140. So there's confusion there because it doesn't really specify which of the area on that 140 acres is being allocated.
Right. Yes. I mean, and that's what I found when I went out. Was that, you know, I was looking at land that looked like it was built on and had been. So is that something that can be addressed? Can the allocation reflect, or I mean, what can you explain why the map is different to the what the allocation is?
I'll ask Mr. Malloy if he can just explain what the thinking was behind how the map is depicted at the moment. But certainly, I think in terms of achieving clarity, I don't think we would see a problem with the principle of, as it were, having notations which try to distinguish between those parts of the site which have already been developed and those parts of the site which are available for development. Obviously, there is a question as to what ought to be the time that you choose to do that. It may be, going back to some of the earlier discussion that we had with Mr. Rivet in relation to some of the housing matters, that perhaps choosing the date of submission of the plan might be a suitable, as it were, point. It's obviously a snapshot, but I say in principle distinguishing between what's already been built out and what remains is not something that we would have a problem with. It's just a question of how you would show that. But perhaps then turning to Mr. Malloy, if he can explain simply currently what the position is.
Yes, thank you. Yeah, so just to echo that, you know, if any amendments to the map would aid with the clarity, then, you know, we'd be happy to look at that. I think essentially the sort of issue, I suppose, comes from it almost being a double allocation as such under SPO 5, with it being a strategic employment site, and therefore it's hatched in blue, and sort of as we touched on earlier, a lot of the strategic employment sites are in existing use, but there is the remaining land allocation, I suppose, where the 64 hectares comes into play. So I suppose it's probably that double allocation where it's perhaps lost a little bit of clarity, but yeah, we can certainly go away and look at that.
Yeah, I think it's I mean, obviously, if you say 64 hectares and then you show 140, I mean, that's I understand that you probably do want to identify the strategic employment sites, because obviously you've got policies that seek to protect those and keep them in employment use, so that you probably do want a line round those as well. But it is confusing when you look at an allocation that says 64 hectares and then you show 140, and so maybe we need to look at how it's shown on the map, so that people are clear, and maybe even within the text, that you know, that what the allocation is and what's strategic employment land. Mr. Knowles, you want to say something?
Thank you, Ma'am. Building Partnerships are developers and advisors in East Anglia. We've been working in the area for over 30 years. What we would accept the council's assessment of the demand for the general employment requirements that are about, such as iAirfield, and other general industrial sites. We think that the assessment they've made on the A14 is wholly inadequate. There are two markets for space in Baber, the general market and then distribution along the A12, A14 corridor. And there have been a number of sites coming forward for allocations. Most recently, planning permission was granted on a site in Stowmarket adjacent to Junction 50. And that was granted within the last month for something like 2.3 million square feet. Yeah, on 160 acres. The requirement for distribution along the A14 has substantially changed in the last 3 years. So our assessment is that the council's employment study probably, well, does not include the level of requirement and demand that is now in the market. Chris Mooney from Savills, if you would like an assessment of that market, is here and can go through generally what he is experiencing. But in general, I would say the market for distribution warehousing along the A14, including areas outside Baber, is about 6.5 million square feet. The current requirements in the last 3 months, there have been Savills have had 3 requirements of 1 million square feet. There is huge increasing demand. There's recently been at Bury St Edmunds just under 1 million square feet taken up on the JNICS scheme. And this is a quantum shift in this area of the market. In East Anglia, I think in my experience in close to 40 years and Chris's experience, I don't think until about the last 3 years there's been any requirement for 1 million square feet in this area. In fact, you'd be lucky to get 100 or 150,000 square feet. So we're looking at a market that probably is going to take up all of the available sites, and your question about acres is pertinent. We think all of those sites will probably be taken up in 5 years, when historically, and the basis of the council assessment for old style general employment, that would have taken probably 25 years to take that space up. So there is a huge need to look at the sites along the A12, A14 west of the Orwell Bridge that can meet requirements to bring in key new employment into the area.
Thank you. I was going to ask about whether people considered the sector need assessment to be out of date. So you've brought me onto that topic nicely. I know there's a couple of other people who want to say something, but Mrs. Travers-Healy, is it related to what has just been said?
Yes, it is. I think you can see from our hearing statements, we had exactly the same point as Mr. Knowles, and I'm actually glad to hear about Mr. Bedford saying about, the complexities between, qualitative need and there not being particularly an oversupply there. My client has found huge demand for warehousing space, and I think given the complexities of the issue, I would be concerned if if the requirement expressed in the policy, if that it was going that way, that needed to be a minimum, because as Mr. Bedford has rightly pointed out, there's qualitative issues there, and Mr. Moles, I'm not going to go over what he said, but we agree. We feel the 2017 assessment is outdated, particularly in terms of logistics and warehousing space.
And Mr. Short.
Thank you. Two comments or two questions, really. I'd echo the comments reference the 2017 assessment, particularly for my client's land holding, which is at Woolpit. Logistics sector, major transport operator employing 130 people from a site in Woolpit. During the course of this GLP review, allocated an additional 3 acres adjacent to its existing site, immediately adjacent to an interchange on the A14. Further representation for another 7/8 acres to the rear of their existing premises, where detailed submission was made with regard to the need to provide for HGV driver training. So some foresight there, I think, but again, denied. Woefully inadequate for that particular sector. The second is more of that's a comment. The second question I have is in relation to the Lady Lane site in Hadley, the vast majority of which is occupied by premises that are probably now approaching 50, if not 60 years of age. The Lady Lane allocation it's a misnomer because it's not an allocation, it's a recognition of protection and retention of an existing employment site. But my question is this: given that the premises on that site are of some vintage and the need for qualitative replacement, reflecting accommodation needs in 2021 and beyond, Hadley's a very local market, and I think your own document makes reference to that. In terms of new accommodation and therefore delivering the qualitative need that's been identified as acknowledged and recognised, given that it's a local market, where in Hadley is it going to go? There's no allocation.
Thank you. Can I first come back to the council in terms of what Mr. Knowles and Mrs. Traverse-Healy have said about in terms of the sector analysis needs assessment and the fact that it may well be out of date now. What's your response to that?
Well, if I start with just some overall comments, and then perhaps Mrs. Candler can comment on how the council sees the position. Obviously, the starting point of this with any other plan is to have a proportionate evidence base, and that is recognised in the NPPF. And in terms of whether or not the evidence base is proportionate, one factor to take into account, but not the only factor, is how up-to-date the information in it is. We have submitted, obviously, the Economic Area Sector Needs Assessment Final Report, EC03, which was undertaken in September 2017, so far as its final publication. And we are in a circumstance where clearly it could be said that there have been some changes of circumstance in the succeeding 4 years, but in terms of whether that renders the analysis out of date, we don't accept that. Obviously, some of the changes are what you might call temporary in nature. We have had, obviously, as everybody on this remote hearing will understand, something of a remarkable 18 months to 24 months due to the pandemic, which has itself changed matters. And we've also had some changes which, again, it may be said are temporary in nature, associated with the 2016 decision to leave the European Union. But nonetheless, the fundamentals of the structure of the economy in the 2 districts and the fundamentals of what is needed to service that economy, and particularly the transportation, communications networks, have not changed. And so we don't see it as being demonstrated that a study from 2017 is no longer fit for purpose, an appropriate basis for forward planning, particularly if then the policy framework which flows from that is a flexible policy framework rather than a restrictive policy framework. And we can certainly accept the point, I think, made by Mrs. Travis Healy, that if one is to express numbers in the plan to reference what the quantitative position is, that they should not be expressed as ceilings, but merely as minimum provision, to make it clear that, say, the qualitative factors overlay that quantitative assessment. But given I say that the plan takes a flexible approach, we don't see that the evidence base should be regarded as out of date, or that the evidence base is no longer proportionate to supporting the policy framework. So that's the overall position. And then perhaps if Mrs. Candler wants to make any more specific comments.
Thank you. Yes, in terms of the local context to that, I mean, it's clear that we do have flexibility. The site which was referred to, recently granted planning permission, is the Mill Lane site, which is indeed one of our strategic allocations under SPO 5A. That's for 52 hectares of employment land, which has been granted subject to 106 at present. And that's an extensive site on the transportation corridor at Stowmarket. I should also say, in terms of our strategic sites and the flexibility, we also have, in addition to the strategic sites, extensions to them around the Worsted site, again along the transportation corridor. So that's the Worsted SPO 5, the B site. We have a further 13 hectares currently granted with extant planning permission. And in addition to that, in the same area, there's another further 5 hectares subject to 106. And also along the transportation corridor at Great Blakenham, we've got a further 8 hectares granted subject to planning permission. Now, all of those sites, or those I should say, extensions to the sites listed in SPO 5. So we believe the baseline, as we said, is absolutely fit for purpose and has helped us identify our strategic locations for employment use. And combined with that, obviously, we've got the flexible approach as set out in SPO 5. As well as the background of the planning permissions which have been granted since the base date, which does enable us the flexibility to respond to, I think, what we've all found as unforeseen economic circumstances, particularly over the last 12 months.
Thank you. Is there anything, Mr. Knowles or Mr. Traverse Healy, you want to come back on from what the councillor said? Mr. Knowles?
Sorry, Ma'am, it takes a bit to tick all the boxes in order to get back on. I think we agree with the council in terms of general employment, but don't accept what they're saying in terms of distribution and warehousing. The Mill Lane site, for example, we used to deal with before it was sent to before it was purchased by the council. And we got the initial planning permission on half of that site as a company. As Savills act on behalf of that site, we can say that there are inquiries at the moment for 50% of the space on that development. Remember, it's 2.3 million square feet. So, and those are they're not all the inquiries, they're the credible inquiries that can be potentially delivered in the next 2 years. Again, when we dealt with that site, we were looking for general industrial. We got a B1, B2, B8, sorry, the old technology, and I'm still talking about B1, which was our application. And we were anticipating that to be a 25-year take up on that site. So I don't think we agree that the council's assessment on the strategic corridor, which is the A14, is correct. There is not sufficient allocation of space for demand in the market.
May I speak?
Yes, you may.
Yes, I'm Chris Moody from Savills, responsible for business space, based in the Ipswich office. And I've been in Ipswich for 35 years. And it is fair to say that at the coalface of this market, I can shine a light on it, in the sense that traditionally, up to the late 20-teens, we have seen local churn from what is largely non-aspirational companies absorbing and moving in and amongst existing stock. But over the last 3 years or so, we've seen this tremendous new emerging market where companies want to bring their goods from Felixstowe on a short haul along the A14 for revanning and redistribution. And these new hubs are making existing stock look like antiques overnight. Companies want major buildings. We've mentioned one at Bury St Edmunds of 870,000 square feet. We've got another one in solicitors' hands of 1 million square feet. We've been the agent on the sugar beet factory at Sproughton Road, where we disposed of half the site in 2 deals. There's a large portion of it under offer, and we've got interest on the remaining land. The council could be out of that site in 6 months. Demand is exponential, and people use these terms, they use these metaphors, but we are seeing a seriously burgeoning new market, which has all emerged in the last 36 months or so. And it is sustainable. These companies are either buying their freeholds or taking minimum 20-year leases. So they're there for the long term. It's very sustainable, and I think the model will continue to grow. And I think in a recent survey, it's been shown that the East region here is the fastest growing logistics market in the UK. I could go on, but I don't want to monopolise your time unnecessarily, but it's a subject I'm very passionate about. There's a tremendous market, a tremendous appetite, and we need these quality A14 sites released because that's what the logistics distribution sector require. And I'm happy to take any questions.
So you were saying your view is that that was starting before the pandemic hit.
Yes.
It's not just something that's come out of the pandemic, it was already started before then.
Correct. The pandemic has helped fuel the trading of these sites because there's been an even stronger reversion to online shopping. But the demand was there anyway. The first one was LDH Ladoria, who came out of Felixstowe and took 240,000 square feet on the Gateway 14 site, which is the former sugar beet factory. And then Amazon came along. Now Amazon have obviously, had an upturn in business with the pandemic. We've got a Chinese company, FDS, who've taken 140,000 square feet at Great Blakenham, Junction 52. We've got commitments from parties to take, a substantial amount of space. That scheme is going tremendously well. We just can't keep up with it. I should be retired, but I'm still here. I'm in the autumn of my working years, but this is just keeping me so busy. The demand is so strong that it's a very, very exciting period. We have gone from the sublime to the Corblimey.
Thank you. Mrs. Traverse-Healy.
Thank you, Madam. I don't want to repeat too much what Mr. Knoll said. I do agree on that point. I think we're really at a tipping point here of no, readily available land, and I would just to disagree with Mr. Bedford on his point. I do think the assessment is out of date, and we're looking at especially from a warehousing logistics perspective. And on that point, I do appreciate that it's hard to always predict these trends and where they're going to go. And for that part, we have expressed in our rep our support for part 6 of that policy on SP 05 in terms of employment uses coming forward that maybe not have been identified before. And I think that's quite relevant here now, in given what we're talking about. So I just wanted to say our support for that part of the policy in terms of those needs that cannot be anticipated.
Thank you. I think we've just probably discussed that as much as I can, and we'll then, if we look at the policy itself, because obviously that will pick up on some of those issues and whether it provides the flexibility that is needed to pick up some of this unanticipated or this growth in demand that is being suggested. There's a few minor things I need to just pick up on the in terms of the wording of the policy. In criteria 3, where it says existing employment uses should be retained, I think it should probably be existing employment sites, because you obviously can't retain a use, but you can retain a site. So we just need to pick that up. And there's some other minor typos in that and in part 6 that just need to be picked up as additional modifications. I would like to look at criteria 3. Oh, and just one other thing too that I picked up on. Sorry, that it's a relative minor point. So I think there's 3 places where you list the kind of strategic employment site. So in 9.16 and then in 9.23 and then also in policy SPO5, and just in 9.23 radon isn't mentioned at all, but it is in the other 2. So again, that's just a relative, probably a minor thing, but just needs to be picked up to provide the consistency. In terms of part 3, oh, I see Mrs. Darry, you've got your hand up. Would you like to want to make a comment?
Thank you, ma'am. My comment was really in relation to criteria 4, so I may well have come in a bit too early. Would you like me to come back?
Yes, I'm going to come on to criteria 4. I'll do criteria 3 first, though, and I'll come back to you when we get to that. Mr. Cook, I know you, Amber REI, have expressed concerns with criteria 3. I wondered if you could perhaps briefly outline those.
Yes, thank you, Ma'am. I was about to put my hand up, but I thought I'd wait to see what questions you were going to ask. Yes, so for context, for the benefit of those on the call who won't be aware of who Amber REI are, we effectively represent them, and their land interest is site allocation LA020, which is a poultry factory which is allocated for residential development. It was originally allocated within the I neighbourhood plan, which has now been made, and it's been subsequently carried forward into this plan. But yes, the long and short of our objection to part 3 is that, particularly around the land swap element, so it's the second sentence of part 3 as opposed to the first sentence. We don't particularly have any quarrels with the first sentence, and obviously we're not seeking to suggest that all employment sites should all of a sudden be redeveloped. That's clearly not appropriate. But our concern with the land swap element is that there's no basis in planning policy or guidance for the principle of land swapping, as far as I can tell. And it raises a myriad of questions, not least for which is how it would be achieved. So we've clearly discussed this morning already the issue of qualitative versus quantitative, and again we accept the council's evidence that there is an issue with quality in Baber and Mid Suffolk, but if hypothetically you are seeking to redevelop a low quality employment site for an alternative use, and that triggers this requirement for a land swap, what is the scope of that land swap? Is it simply a red line around a piece of land and we say here you go, or does that land need to have planning permission for an employment use before the council will let go of the existing use? And if so, is the proposed use of an equal quality? Because if you're swapping poor quality for poor quality, I would suggest that doesn't solve the council's problem. I would suggest that if you are land swapping, then the new, in an ideal scenario, would obviously be better. But then that leads you into MPPF territory and obligations, in that I don't think swapping old for new is fairly unreasonable, and I don't think it would meet the tests for obligations. And then sort of segueing away from that is that if the answer to that question is that yes, the new land does require planning permission, the viability assessment that we discussed a bit this morning and again yesterday, document ER02, page 2 of appendix 1 of that document, which is PDF page 99, if that helps. It summarizes this policy and the impact upon viability, and it says the impact of this policy on viability is low, and then it says no direct impact upon appraisal assumptions, but employment scenarios have been viability tested. I would suggest that if your new site you're land swapping to does need planning permission, I would suggest that the impact upon viability is not low. I mean, as people on this call will know, achieving a planning permission is not cheap. And there's no assumptions, as far as I can see, that would even attempt to put a ballpark figure on achieving a planning permission in the assessment. And I won't go on too much further, but again, coming back to my point about who I represent, we are a residential allocation on a former employment site through a neighbourhood plan and then subsequently through this plan. So our query really is, are we still required to go through that land swap process, given the principle of the loss of the employment use has already been accepted both by the makers of the neighbourhood plan, which you would anticipate to be representative of the views of the community. So the community have already accepted the principle of this employment loss. And given that it's been carried forward into this plan as well, this draft plan that we're talking about today, then again, the principle of that loss has been accepted, and yet there's still this question mark of the land swap, and it's not a question for now, but that's principle of that comment in relation to employment lands that I will be raising in respect of several other policies later on, Ma'am. But hopefully that's clear. But if there's any further questions on that, I'm happy to try and explain further.
Yeah, no, you've raised a lot of the issues that I've noted. Perhaps I can come to the council straight away. I mean, obviously there was quite a lot of things that Mr. Cook raised there in terms of this criteria in the land swap, in terms of what's required, whether it will meet the SIL tests, whether it what is expected in terms of the land swap, in terms of whether planning permission impact on viability. So perhaps you could address some of those for me. So what your views are in terms of how you think this is going to operate.
Thank you, Madam. Madam, if I perhaps start, and then maybe Mr. Malloy can comment on any of the specific matters. First of all, just by way of clarification, I'm not clear. Are you expecting to deal with the particular circumstances of the particular site that Mr. Cook has an interest in during the course of this session? Because I didn't think that this session was intending to be concerned with site specifics.
No, we're not dealing with site specifics, but obviously it raises a number of issues that aren't site specific in terms of whether, sites that have been allocated that are on, for employment uses generally that aren't and for other purposes, are they required? Would it meet the SIL tests? What in terms of what's required is planning permission expected to be sought for the land, and things like that. So that, I mean, those aren't they aren't site specifics. They would be relevant to a number of sites, not just Mr. Cook's.
Yes, well, Madam, I say dealing with the matter in terms of generality as opposed to site specifics. Obviously, the premise of SB05 Criterion 3 is that there is a planning purpose served through the existing employment use on an existing employment site. And that planning purpose is the provision of local employment in that location over the planned period. And therefore, from that starting point, there is something of value to the planning system on the site. That's a resource. And if that resource is to be lost through a proposal for redevelopment, then it is entirely legitimate for the planning policy response to be to expect effectively restitution for that loss. And in terms of a redevelopment, the restitution can't be on the site itself. It would be primarily through a land swap, or alternatively, if there is no suitable site currently available for a land swap, a contribution to enable alternative employment provision to be secured. And both of those are effectively methods of mitigating, using that concept in its broadest terms, mitigating for the loss of the resource which is being removed. And I say I'm using mitigating in the broadest sense, but you will know that in terms of environmental impact assessment, there are what you might call gradations of dealing with harm. So there's avoiding harm by it not happening. There's minimizing harm, so that you put in mitigation to reduce the harm. And where harm can't be avoided or minimized, so you're left with residual harm, there's then offsetting, which is sometimes referred to as compensation, but effectively it means improving something else because you can't avoid the harm to the thing which is being lost. And effectively what item 3 is seeking to deal with is where there is a loss of resource, then it's looking for mitigation for that loss of resource, either through alternative provision through a land swap or through contributions to enable alternative provision in some other form. So we see that as a legitimate response to the loss of a resource. As to whether or not planning permission would be required in relation to the alternative site, well, it may or it may not be, because it obviously depend on the circumstances that are applicable to that alternative site. I mean, if a site may have a planning permission but had some impediment to it coming forward, which is why, in a sense, it hadn't already happened, then it may be that the proposal could provide a mechanism for addressing whatever that impediment was, so as to enable it to come forward, in which case it could come forward on a site which already has planning permission. But if it was a site which didn't already have planning permission, then it may be necessary to secure that planning permission to show that the land swap would be effective. So that's the kind of like the overall background. And then if I perhaps ask Mr. Malloy if there's anything particular he wanted to add on the matters that Mr. Cook was raising.
No, I mean, in terms of response to that, I think Mr. Bedford's covered the sort of council's position on that. Yeah, so we don't really have anything further to add.
So in a circumstance where a site is allocated in this plan or in a neighbourhood plan, would that land swap still be expected? If it's allocated, if an employment site is allocated for another use, would you still expect a land swap to take place?
Sorry, apologies for missing out that supplementary question. No, the intention is that would apply to almost windfall developments. Yeah, we obviously accept that the site that Mr. Cook refers to has been through the neighbourhood plan process with which is a made neighbourhood plan, and yeah, through the joint local plan as well, through that plan-led system, it's been determined that is a suitable site for residential. So the intention is that it would apply to windfall developments. Whether we would need any clarity on that in the background text, or whether, because I'm trying to think whether I think I is probably the exception to the rule. So yeah, whether we can look at that in the background text, or you know, it would be dealt with through a departure, then yeah, we're happy to look at that.
Right, yes. And what about a site where it's been shown that employment isn't viable on that site, Is that still, would a land swap still be required then when if they've provided viability evidence that it's not possible to put employment on there anymore?
I think it would be a question of looking at the particular circumstances as to what any kind of viability assessment was showing. If a viability assessment was merely showing that the previous employment use, whatever that might be, but which might be particularly specialised, let's say poultry processing, I think is the example that Mr. Cook had an interest in, then merely showing that the site was not viable for poultry processing, we don't think would avoid the need to go through the policy test. Obviously, if a viability assessment was able to show that there were no conceivable practical employment uses for any part of the site, bearing in mind the full range of employment uses. I know we haven't yet talked about how broad that concept is, but bearing in mind the full range of employment uses and not merely whatever may have been the historic use, then I don't think we would accept that that would, be sufficient. I say if the site had no future as an employment site, then that would be a factor to then be weighed against the policy requirement. But that may be, I say, fairly few and far between when you have regard to the full range of potential employment uses that may be capable of being accommodated on a site.
Mr. Cook, do you want to come back?
Yes, thank you. And yeah, apologies for raising a specific site. I know this isn't the site's session, but I had to explain where I was coming from a little bit. So apologies for that. But I think we would be appreciative if that clarification that Mr. Malloy referred to, that this part 3 is only applicable to windfalls. I think that would clarify. That would be helpful in clarifying that. But I still must confess I'm struggling to get my head around not the concept of the land swap, but the practicalities of the land swaps at development management stage. I can just see, parking my own client's interest for a second, I would struggle to understand how many people would actually have land available to swap. I suspect it's very few, and of that land that is available to swap, I would expect even less of it to be actually appropriate for employment uses. I would suspect the vast majority of these alternative sites would fail due to them being sequentially unacceptable for employment uses, or their nearby residential uses, and therefore you would have amenity issues, etc. And if the land to be swapped happened to be either an existing employment allocation in this plan or happened to be on an existing industrial estate or whatever, then by going through with the swap, I don't see how the council has gained anything, because that site is already in employment use and it's already an allocation, and therefore that's already in the employment bank, if that's an appropriate way of phrasing it. And if the land swap is taken out of the equation and it's merely a financial obligation, then it's a question of how is that money, well, firstly, who is the money paid to? Would a hypothetical developer pay some money towards, using our airfield as an example, because we mentioned it this morning, would they pay the money to another developer in airfield to further improve their employment offer, or does it go to the council, and then how does the council spend it? But that then relies on the council having suitable sites under their ownership to spend the money. It's just, I'm not quibbling the principle, I'm struggling with the practicalities of it, Ma'am.
Yeah, Lady Hart, do you want to you're still on mute, Lady Hart.
Yeah, apologies. It was to ask the council, please, through you, Ma'am, for qualification on the first sentence of criterion 3, where it says existing employment site should be retained. Does that mean sites which are allocated for employment at the point of the commencement of the plan? Or if not, what does it mean?
Thank you. I'll get the council to come back. I've just got Miss Darry, your hands up. Do you? Oh, no, maybe that was a redundant hand. Mr. Short, do you want to come in on this discussion too?
Just a very brief point, whilst acknowledging the difficulties that Mr. Cook has, such opportunities do exist, and in fact I have just such an opportunity before this council at the present time. So I would not want to see the facility or flexibility for a land swap lost from policy.
Right. So to council, do you want to respond to kind of Lady Hart's question about that first sentence and what it means, and also come back to Mr. Cook's kind of questions on some of the practicalities of how it's going to work, so I can understand, you know, whether it would do.
Thank you, Madam. If I bring in Mr. Malloy to comment on those 2 points first of all, and then if I necessarily, I'll make some further comments. Oh, sorry, Mrs. Candler. I apologise rather than Mr. Malloy.
Thank you. And in terms of the practicalities of how it could work, we had set some information out in document, bear with me, I-601 in terms of the council's hearing statement. We did an initial response.
Sorry, what was that number? I didn't quite catch that.
The council's hearing statement, I think it's I-601.
60, right, yeah.
Thank you. And we put out some initial information in there, and we had set out that the detail, it would be looking at a land swap and or financial contribution. And the detail of that we would be looking to develop through SPD. But the calculation itself in terms of practicality of how we could look at it could perhaps be upon benchmarking the value of the land lost using the valuation office and looking at mitigation proportionate to some pre-agreed provisions. Now, in terms of where that investment could go into, for example, one of the issues, when we come back to the qualitative issues of employment land supply, a main factor across our district is the access to good infrastructure, including ICT infrastructure, etc. And one of the mechanisms which we've been exploring could some of that go towards enhancement on and along our strategic sites to provide better capacity and improve that. So the land swap isn't the only answer that we'd be looking at, but we would be looking to develop the detail of the actual mechanism for the contribution through an SPD process. But we believe it could be done, and we have looked at other authorities where this is put into practice and works, and helping enhance that strategic quality of the network of sites and the infrastructure, which is an all-important element across Bayber and Mid-Suffolk.
Is that SPD set out in your LDS at all, or what's?
I'd need to. No, it's not. No, not at this stage. No, we need to look at that.
So I mean, in the meantime, if that's not in preparation, how would it work if the details aren't there?
Would need to be working up the details in parallel, so we haven't got the full details worked up at this stage.
So how would it work until that SPD is there if the details aren't there?
It wouldn't be put into place until the SPD was there.
Mr. Cook, do you want to come back?
Only very briefly, Ma'am. I don't want to drag this point out much longer. I know we've got a lot to cover today, but I think that answer really is just underlined the fact that I think there are question marks over this policy still, and if a calculation or formula was to be included in SPD, clearly that wouldn't go through the same process of examination that we're at now, and therefore wouldn't be subject to the same scrutiny. And whatever the bottom line figure, if you like, the output of that formula isn't captured in the viability assessments, and therefore there's question marks over the viability of this policy still. But to summarise, I think I've made the points fairly clear, and I think there is still work to be done on this policy. But the headline that again Mr. Malloy agreed to is making that clear that it doesn't apply to allocations, and I think my client was satisfied with that. So yeah, I don't wish to drag this point on any further. Thank you.
Yeah, thank you. Well, I want to think about that. From what I've heard, I want to think about. I have got concerns over this land swap and how it would work. I want to think about that further. I certainly want you to. I mean, I think we need to look at that suggestion that of clarity of when it will apply. I think if you are suggesting an SPD, then that needs to be flagged up as well. That the details of that will be set out in that, and obviously it needs to be put in the LDS. But I want to think about that more as well in terms of how that will work. Perhaps we can turn on to criteria 4 now.
Madam, I'm just conscious that we didn't in that response, I think, directly answer Lady Hart's.
Oh right, yes,
question.
No, sorry.
We dealt with Mr. Cook's, but so perhaps again, I don't know whether Mrs. Candler is the person who's going to deal with the question of is the intention that if criterion 3 refers to existing employment sites and says that they should be retained, will that also cover sites which are allocations rather than having been currently developed?
I think the intent would be to maintain all so it's looking at all existing employment sites in this instance. We're dealing with our strategic employment sites in SPO5, but it would be the allocated sites and employment uses would be looking at retention of, but the land swap element itself and the contribution element we're only looking at in the context of SPO5, so our strategic employment sites. We have other policies to address more general loss of employment land, LP12 and 13, which I'm sure we'll come on to. This is concerned with the strategic sites. I think the council have clarified that point in, oh, excuse me, I think it was document GO2. I need to double check that reference.
Lady Hart, is that
no, no, it doesn't, I'm afraid. I'm sorry if I'm being slow. Does by existing employment sites mean those which are existing at the point of this plan coming into force, or does it mean other currently existing sites which may be carried forward? It's just not clear to the parish, and we are concerned with one site in particular, so we'd like to understand it clearly.
Just where's that amendment we put for?
Yeah, so because were you saying it's only the strategic sites, not all sites?
Sorry to.
Yes. Yeah.
Yes. In terms of the amendment, we sought to clarify that part 3 of the policy is applicable to strategic employment sites.
Well, I think that needs to be clarified as well when you look at the wording, because at the moment it just says existing employment site should, that could mean anything that's in employment. If you're just looking at strategic, and we're just looking at those that are listed in in part 1 as your strategic sites, that needs to be made clear, because obviously that does affect. Because then you're saying the land swap on other sites wouldn't need to take place, if it's not a strategic site.
Yes, that was the intent, and you'll see amendments that we had put forward under policy LP12 that sought to address that point.
Right. So if we look at criteria 4, then.
Ma'am, could I just follow up with just
yes.
a clarification? It is one of the things that's listed in the council's hearing statement under 10. Chiltern Parish Council had a query about the definition in 1B of this policy SP05. It says Sudbury, Chiltern Industrial Estate, Delphi site, Churchfield Road. And we had a point that Churchfield was 2 words rather than 1. I mean, that's obviously just a minor amendment. Now, the council say in response to that, noted. So we're not clear, are they going to change that or not? And also, is it intended to mean Delphi site on Churchfield Road, or is it meant to be Delphi site, Churchfield Road, part Chiltern Parish as a separate site? It's not clear to us what is meant as the strategic sites. Because Churchfield Road forms part of the Chiltern Industrial Estate, you see. So that's why we're querying what's the part of Churchfield Road in Chiltern Parish. If it's the Delphi site at Churchfield Road, then that's clearer, but we're not certain if it's 3 sites or 2.
Right, perhaps can the council just quickly just clarify that?
Yes, thank you. So in terms of the actual the land allocated under those areas, they are set out in the relevant maps on part 3 of the plan. So around the Sudbury area, because of the tight parish boundaries, it may well appear under a Sudbury map and a Chiltern map and a Great Cornard map. So if sorry, just trying to get my plan. I mean, the intention is, yeah, so we have the Chiltern Industrial Estate, the Delphi site, and around Churchfield Road, there is a large employment site, I suppose, and we've got Northern Road. So yeah, we can look to tidy up that in terms of actually identifying the land mass, I suppose, around those sites. Sorry, I'm just trying to flick through the plan to find the relevant page for you.
If it helps, the Chiltern map is at page 197.
Ah, excellent. Yes, just got there as you said that. So yeah, so that essentially is the land allocated under SP05. And yeah, we can look to clarify the identification of the different site names in the policy if required.
Yes, thank you. That'd be helpful. So so moving to criteria 4. Mrs. Darry, do you want, I know you said you wanted to raise that. Do you want to come in now?
Yes, thank you, Mum. Our query on this one was the clarity of the wording. And I think it's down to the use of the words or in the first part of the criteria. So it says applications for full flexibility or for a single or flexible use. And we're not quite sure what that actually means. So part of this criteria has been pulled forward into the specific allocation sites. So our interest specifically is in LEO 14 at Poplar Lane. So we recently had cause to speak to the development management section within Bayber Council to try and establish what this was actually trying to achieve or enable as part of the employment on that particular site. And we were all a bit stumped, to be honest. We couldn't really work it out. We kind of just thought it ought to say applications for full flexibility involving one or more of the uses within Class E. But it's a clarity point more than anything. If the development management section within the council don't know how to interpret that particular criteria, I think that's a bit of a problem.
Yeah. Thank you.
Thank you.
I wonder, I mean, can the council explain the approach you're seeking to take in this criteria in terms of regards to Class E and changes of use? And probably pick up Mrs. Darry's point in that.
Again, perhaps if I start, this criterion relates effectively to what will turn out to be probably a transitional period, but it's a transitional period which at the moment could be quite extensive, because to all unimplemented extant relevant permissions prior to September 2020. Because obviously you'll be aware of the changes to the use classes order that took effect at that point. But those changes to the use classes order were not retrospective. So there will be planning permissions that were granted prior to that date, which will use the, as it were, pre-use class order amendments terminology for any uses that they authorise. And they may be uses in the former class B1, but they may be other employment uses, but they wouldn't necessarily fit within what is now class E. So we've got as it were, a pool of unimplemented extant relevant planning permissions which don't benefit from the new Class E provisions. And the persons who want to bring forward those planning permissions may have a wide variety of, in a sense, different proposals as to what they want to do. They may want a full flexible use, recognising that Class E has to some extent changed the landscape, but they can't benefit from Class E, so they may want to achieve that. They may have in mind a particular use that they want to bring forward, or indeed they may want to not even be subject to Class E at all, but want a wide range of uses. So all this is saying is that where people bring forward such proposals, but they're obviously currently stuck with their existing relevant planning permission, then they will need to make an application, and that will need to be considered on its own merits. Maybe there were different ways that we could have expressed that, but hopefully we were making it clear that it was, as it were, ensuring that since whatever it was that people wanted to do with those existing planning permissions in terms of taking advantage of any additional flexibility, that would need to be considered on its own merits in the light of what the current planning permission would allow them to do, and then what would be the position were a fresh application to be made, which would fall to be considered in the light of the freedoms that are now granted by Class E. So I think that was our intention. I don't know whether there's anything further. Yeah, well, Mrs. Candle just had some further comments.
Thank you. If I may, using the example of the Poplar Lane scheme, obviously that's the 2018 exam planning permission. The residential element's been implemented. The employment part hasn't yet been implemented. So the permission itself would be for your more, if you like, B-type uses. So should they be looking to go for a more flexible use, as Mr. Bedford has said, it would be going through the planning process to do so, whether that be undertaking retail assessment work, for example, or whatever else, so the application could be looked at on its merits. That was the intent of that part of the policy.
Well, if the intent is just that to say the application is going to be considered on its merits, is it really necessary? Because surely that is what we have to do. We consider every application on its merits.
No, my apologies for being unclear. The intent of it was to look at the uses which would come forward for the full flexibility for use class E, and to make it clear that if use was in place, obviously the use class order and use class provisions run simultaneously, but if a site is granted for employment use, we would want to look at it going through that planning process, and also importantly for new uses which are granted. And we have the example of the site we've already discussed this morning at Mill Lane, 52 hectares at Stowmarket, where conditions, the agreement put onto that planning permission restrict movement within the use class, so it is granted against B uses, and should the scheme wish to go forward for more flexible uses, it would go through the planning process. So it's to make that clear that it wouldn't automatically be into use class E.
Right. Mr. Knowles, you want to come in?
Thank you, Mum. I'm still not quite clear because the flexibility I assumed was for commercial uses. So if, for example, if a site has been allocated for B2, B8, for example, and other uses are then generated, which is similar, I think, as what's happened to the site that has been used as the example. Are they saying that the site allocation, i.e. B2, B8, is the flexible uses, or is the planning permission that's granted that can't be implemented the uses? But that seems a bit illogical if you can't implement it because it's not viable.
Yeah. Would the council like to come back on that?
I don't think that in the instance of a B2, B8, if that was a planning permission, that planning permission wouldn't benefit from flexibility in terms of Class E, in terms of there is no ability to change a B2 permission into anything other than 500 square metres of B8, because the previous ability to utilise B1 is not now a feature of the use classes order. So I don't think we would see a planning permission with an existing B2 or B8 use as being dealt with in this way. That would be something which would be considered outside of criterion SP054. What this is targeting are those planning permissions which, had they been granted after September 2020, would have been granted expressed in terms of a Class E use. Well, that will not apply to a B2 or a B8 planning permission, because that would not be granted and expressed in terms of a Class E use, because the definition of B2 expressly excludes uses within Class E. And I say the only freedom that you've got with a B2 permission is to go to up to 500 square metres of B8. Obviously, if you had a site which had such a planning permission and it could be demonstrated that it wasn't viable for B2 or B8, which might sound slightly surprising given what Mr. Knowles was telling us earlier about the burgeoning demand for logistics uses. But if that were the case, then obviously if it could be demonstrated it wasn't viable for that form of employment provision, consideration would be given to other forms of employment provision.
Right, so to be clear, so I'm clear that the aim of this is that it's to pick up the extant permissions that were made under the old use classes, as opposed to before it was changed to Class E. Is that right?
Well, that's certainly what the second sentence is telling us.
Right. Yeah. Right. So it's not for all kind of. I'm trying to just get my head around what it's applying for.
I mean, if somebody has a planning permission for a Class E use, i.e. a post-2020, September 2020 permission, and as you know, there was a further transitional provision through to the earlier part of this year in terms of the terminology. But if somebody's got a planning permission and that then is implemented, they will have the freedoms of Class E.
Yeah.
And since this plan, whatever this plan says, will make no difference to them. Obviously, if they don't implement that planning permission, then they don't have the benefit of being able to make changes under Class E, because the permission, obviously Class E only applies if you've got land or buildings in a use which is a Class E use, then you can obviously make a change to another Class E use. But that's a different point to, I think, what this criterion 4 is dealing with.
Right, yeah. Right, with that, we've gone past 11 o'clock. So although we've still got things to discuss on SPO5, I want to just give us a break now, and we'll be back at 11:30. Right, it's now 11:30, so I'm going to resume the hearing session. I'm conscious that because we were beginning to overrun a little bit, I didn't give anyone in terms of criteria 4. I just wanted to check whether there was anyone else who wanted to raise anything in terms of criteria 4 before we moved on to some question about criteria 6. Mrs. Darry.
Thank you, Mum. It's just a simple question. We're still confused about what happens when you take this part of the criteria over into a specific allocation policy. So, for example, the land at Poplar Lane LAO 14 allocation cites the site size, says it's approximately 475 dwellings and 4 hectares of employment land. We then have the criteria that we've just seen there in part 4, which excludes the bit about the 2020 transition. And then we have the next part of the allocation policy just says development for this site shall be expected to comply with the relevant plan policies and contributions subject to open space, healthcare, etc. So what we can't quite understand is, in the circumstance where you'd want to do something on that site that's out with the E classes, how do you then deal with that in policy terms? So for a B2, B8 way of example, we can't quite get our heads around what this allocation is actually telling us we can actually do on this site in policy terms. That's the bit we're struggling with. And we did actually have another planning consultancy did some due diligence on this site not that long ago, and they took the policy and read it and were very concerned that it was actually only saying that the site was allocated for E-class uses. That's the bit we're struggling with.
Right, so is this a question about a specific site allocation?
Well, I think I haven't looked at all of the other allocations, so I don't quite know whether this wording translates into the other allocations just in this particular way. So it's general, but also specific to this allocation.
Because obviously we're dealing with the site specifics when we deal with matter 9, so I don't want to get into what can happen on that site now, because I mean, if it's something specific to what this policy says, I can deal with it, but I don't want to deal with something that I'm going to be dealing with in matter 9.
That's fine.
Right, thanks.
That's fine, thank you.
Thank you. Mrs. Travers-Healy.
Hi, Mum, you might have just answered my question actually, but I'll just raise it. I actually had a comment to make in regards to Part 1 Worsted Business Park. And because it was in SP05, I wondered if I could make it here, or is this then a comment raised in matter 9?
I mean, it depends what, if it's I don't want to get into the specifics of the allocations that we're going to deal with in matter 9. I mean, so if it's something that's wrong in SP05,
well, it concerns the extent of the allocation.
Right. No, I think that we need to deal with that in when we deal with matter 9,
Okay.
rather than now.
All right. Thank you for the clarification. Thank you.
Mr. Short.
Yeah, thank you. It was along the same sorts of lines. We've got a site which is allocated by SP05, but it doesn't have its own individual site allocations policy, which might come under matter 9. So it's just a query as to when do we deal with that? Is it now, or do we come under matter 9 in due course?
So where's it allocated in SP05?
It's the Lady Lane site in Hadley.
Right.
And it doesn't have its own site-specific LA reference policy. It's only in the SP05. So it's just a case of when do we deal with those?
Right. Well, we probably need to just pick that up. What specific is it about that you want to raise? Can I?
It's the allocation. We don't think it should be allocated for employment use.
Right. And
but I'm also conscious of the fact that Mr. Bedford said this morning that the council weren't prepared to deal with site-specific queries. So
yes, I mean, I think it might be best if we do deal with that under matter 9 in terms, although it's not a specific allocation, we are looking at things in terms of, so when we look at Hadley that as well, I think it'd be better to pick it up there than now, because I'm not briefed on the matter 9 stuff now and things like that, so I think we need to look at it there. Thank you for flagging that up, and we'll be aware that we need to raise that under matter 9.
Thank you. And I guess the same comment, because we've got another site in Woolpit, I guess the same will come.
Right, yes, yeah.
Thank you.
Mr. Bedford.
Thank you, Madam. So there was a point that I needed to clarify from what we were saying before the break, which we've just been reflecting on in terms of criterion 4, and it's that second sentence which certainly we do need to I think revisit to make it clearer. But one of the points that we have not identified so far, but which we think probably is the case, there may be planning permissions in relation to the strategic employment sites that were granted after September 2020, but which were then the subject of conditions on those planning permissions because of their particular circumstances, which restrict the uses that can come forward. So they don't have the full freedoms that you would otherwise have under Class E because of the conditions that have been imposed as a development management decision in relation to that particular planning permission. And in relation to any such permissions, then similarly, if there were a subsequent application made for full flexibility or for a different use to what was already authorised, bearing in mind those restrictions, then again we would want to apply the approach in criterion 4 to that. So in essence, I think I said we need to look at the words of that second sentence because at the moment it doesn't really capture all of the circumstances that we would want to apply that approach to.
Right, yes. Well, I'll note that down as an action that you're going to look at.
Thank you, Madam.
Mrs. Feeney?
Thank you. It's just to Mr. Short to please just confirm which of the sessions he feels that fall within his client sites in matter 9, and I can add into the programme.
Thank you.
Thank you.
In terms of SPF 5.2, I just wanted to, in terms of criterion 6, given the discussion we had earlier about the change, particularly in the logistics and warehousing need and demand, whether the kind of criteria 6, whether some of the developers, I wondered if they could give me their views on whether they think that criteria kind of provides sufficient flexibility to help meet that demand that hasn't, that they've said isn't particularly picked up, or they consider isn't picked up in the sector needs assessment. Mrs. Traverse-Healy.
Thank you, Ma'am. Yes, myself and my client, we feel that the part of the policy in part 6, given what we discussed earlier in the demand for logistics space, it's really important, the wording of that policy where it says net additional employment uses along the strategic transport corridors. That is a really crucial part of that policy if we're talking about logistics demand. So I just wanted to make that point. It's not necessarily amendment, but a support for that part of that policy in particular. Thank you.
So you kind of feel that criteria would help ensure that you've got that flexibility.
I think if that wasn't in there, I would be concerned. But given that it is, and it obviously that logistic warehousing demand, it by its nature falls along those strategic transport corridors. We think it's really important that that's in there, especially if notwithstanding our comments that we would like the 2017 employment needs assessment looked at. Especially if that's not going to happen, then this is really important in that policy.
Yeah, thank you. Well, I've got lots to think about from the discussions that we've had, both on the supporting text and SPO5 generally. So I think I've got everything I want on that. On Stradbroke Parish Council, you want to raise something?
Yeah, sorry, I thought you might ask. You asked for the developers, and I'm not a developer.
Oh, right, yeah, sorry, no.
Parish Council has always, and you will see from our representations, been concerned about the poultry processing unit factory at Eye. It's a large employment site, and it was granted permission without an EIA. The impact on the surrounding rural villages is vast for the supply chain. And I wonder how SPO5 actually would take account of that. It talks about that they need to be on the corridor of the A12, the A14 and the A140, yet the poultry Cranswick, who are the processors, talk about accessing their poultry from within 20 miles, and most of it is coming in on B and C roads, small rural roads. And I'm wondering how this policy can be implemented when it just says all proposals demonstrate adequate highway capacity and access. We submitted the guidance, the only guidance notes there are on assessment of road traffic, and in their response, Mid Suffolk have said that they would add a footnote to criteria 6B, but they haven't said what the footnote is, and there's no indication of how that would protect it's the largest poultry processing factory in Europe. It processes 15,000 birds an hour. They want to increase their capacity by adding 40 additional units, and they want to double their capacity to 3.2 million birds a week. Now, each million birds just on the growing side produces 3,000 vehicle movements. So we are wondering, well, partly, I mean, we are going to constantly talk about this through all of the stages, but the word poultry appears, I think, twice in the joint local plan. Yet it is a massive industry in Mid Suffolk, and there's almost no mention of it at all. So we were wondering how SPO5 would be used to ensure that the supply chain for the factory, because to quote one Mid Suffolk consultee once said, well, where did you think the chickens were coming from? The chickens aren't grown on site, they're brought in, and the impact is vast on that area of Mid Suffolk. The A140, as you know, as you visited, it's not a dual carriageway, and it is the biggest road in the area. And even with the two roundabouts that they've placed there, they're terrific, but you need to get to the roundabouts for them to be terrific. And to access the A140 for all of this, and so we are concerned that SPO5 B isn't strong enough to allow officers, when they're determining planning applications, to ensure that there is highway capacity and access. And with all due respect, just saying add a footnote to criteria B, they haven't said what the footnote would say or how that would help. We did state that the MPPF paragraph 108, which is now 110D, states that any significant impacts from the development on the transport network in terms of capacity and congestion or on highway safety can be cost effectively mitigated to an acceptable degree. We're not sure how that is shown in any of this, given the vast amount of vehicle movements that will come with a larger factory on the airfield, or in fact the factory that's there working at capacity.
Right, yeah, I mean, I don't want to get, say, drawn into the specifics of
no, but it's a general thing.
Yes.
This policy can't be used because it doesn't say anything in this site-specific policy. This would be the policy that would be used in assessing any new factory or any new poultry units or any new employment sites.
So, I mean, the concern in general terms is about 6B, therefore, in terms of in highway capacity is and how that's used to assess. Is
and
that
how is it modelled? How is it, you know, because the modelling that they used, the transport modelling produced by WPS, it only looked at the main roads. It didn't look at any of the feeder roads into the A140 or any of the others. So that there's a big area of Mid Suffolk that hasn't been assessed for transport impact.
right,
So
yes.
how it will be assessed and against what?
So because I don't want to get into site specifics, but I mean, like, certainly in terms of general terms, can the council explain how they consider 6B is would address that kind of highway needs adequately?
Madam, if I start and then see whether or not there's any further comment that's needed, you need to read SP056 Criterion B together with the rest of the plan, including policy LP32 on safe, sustainable and active transport. And that includes further references to, in Criterion 1B, transport statement or transport assessment will be required in relation to proposals which are expected or likely to cause significant increase in transport movements. And in relation to non-residential development, that will be considered on a case-by-case basis. So in other words, what the ambit of the transport assessment or transport statement will be. And clearly, if a particular proposal, albeit that it may be complying with SP056 in broad locational terms because it relates to the transport corridor of the A140, nonetheless, the transport assessment will need to show how that transport demand from that site is then distributed on the transport network. And obviously, if there are particular impacts, they will need to be assessed as with any other proposal that causes transport impacts. But it's not appropriate for the development management policies to try to answer in detail what will be the specifics for a specific proposal. The role of the development management policies is simply to ensure that there is as it were, a mechanism to allow those issues to be addressed, and we think that taken together, the policies of the plan will allow those issues to be addressed. How they're to be addressed and how they're to be resolved is not, I say, that's not the function of the plan policies. That will be the function of the development management decision in due course. I'll just check whether there's any. No, I don't think there is anything further that we want to say.
Thank you. Do you want to come back, Mrs. Frowson?
Yeah, you haven't actually said what the footnote's going to say then on 6B. You've just said you're going to add a footnote. And also in LP32, it only talks about residential development. Is there any way that you could, well, what does it say? It talks about residential development between 50 and 80 dwellings, and a transport assessment should accompany residential dwellings of over 80 dwellings. So where is it worth putting in there that this applies to employment sites as well?
Well, I think I don't know whether the version that is being looked at is not the up-to-date version, but the final sentence then says non-residential development will be considered on a case-by-case basis.
Okay, sorry, yeah, I see that now. Thank you. But could you say what the footnote will read on that, so that we've got clarity on whether there is going to be something? You said you're going to put a footnote.
Where was it? Where was the footnote mentioned?
We mentioned it in the annex at the
In
back.
the annex.
Sorry, appendix 1, appendix 01 of the matter
Page
statement.
9. Hearing statement matter 6.
Right.
Fine.
In appendix 1.
I-601. It says policy for modification proposed to address the impact of the poultry, and it says add footnote to criteria B. This would be addressed through amendment to validation checklist and would not require JLP policy. So
Right.
I just wanted the footnote was going to be.
Right. Well, I mean, I think they can come. The council can look at that, and that wording can come back to me, and obviously it will can be discussed at. I don't think they need to produce it now, but we'll look at it. I'll look at it when it comes in, and obviously it will be subject to consultation at the main modification stage as well, if I consider that it's necessary. But I've made a note of it, that I need to look at that in terms of the concerns that you've raised.
Thank you.
So is there anything else on SPO 5? Right, we'll turn to LP 12. No, then.
Oh, sorry, Ma'am. I got a minor point on SP 056, but
right, yes.
D, which we've raised, and in the council's matter statement at point 10, they say that what our point was that D is currently worded, the site design and layout must be sensitive to the surroundings, including any landscape heritage and biodiversity assets. And Chiltern Parish Council had suggested deletion of sensitive and have regard to the landscape heritage and biodiversity assets. And the council's position is that they say the context for heritage consideration is considered appropriate in SPO 5. We think sensitive's more ambiguous and subjective, and will lead to lack of clarity and more arguments on development when applicants apply for planning permission. So we wondered what the, apart from objecting to change it, what the substantive reasoning was for the council's objection to changing it to have regard.
Yeah, I mean, I'm aware of there's a whole variety of issues like that,
okay.
That I can consider. I don't think it's necessary to discuss them here. I am aware of them, and I will consider them when I look at them,
Okay.
and look at the policies and make my recommendations. So I will pick that up, but I don't think it's necessary to discuss it now, if you don't mind.
That's fine, Ma'am. Thank you.
Thank you. So turning to LP 12. I know Mrs. Traverse Healy, I wonder if I could start with you, because I know that you've suggested a main modification that you consider is necessary, and I just wondered if you could explain why you consider it's necessary for the plan to be made sound.
Yeah, I did have a point on this policy. I just think, especially in the context of what we were describing earlier about sort of demand for logistics space, and also referring to paragraph 81 of the NPPF, where it says create conditions in which businesses can invest and expand. We felt that the current wording, the wording of policy LP12 part 1 sets out a number of requirements, as you know, ma'am, for new employment uses. we considered that maybe the policy could be more effective in its support for appropriate proposals, and we suggested the insertion of additional policy wording dealing specifically with the growth and expansion of existing businesses, and being more specific in regard to the broad employment locations where that would be appropriate, for example, the Ipswich Fringe, and being well related to the strategic road network. So that was our comment, our main comment there.
Thank you. Would the council like to address or give their views on that kind of suggestion and whether they consider it's necessary for soundness?
Madam, thank you. In short, no, we don't think it is necessary for soundness. I'm sounding like an old record, but the plan needs to be read as a whole, including obviously the strategic policies, which clearly set out a focus on the settlement hierarchy and the references to the Ipswich Fringe and so on. We don't consider that when you take the strategic policies together with policy LP12 that you need to, as it were, reiterate in LP12 what is already sufficiently set out in the earlier strategic policies.
Mrs. Travers-Healy, would you like to come back on that at all, or are you?
Just a short point. I suppose we feel that in determination of employment applications, LP12 will be quite important. So in that respect, that's why we were looking for this change.
Thank you. Something I'll give consideration to. I know, I mean, I raised a number of issues in terms of definitions, and particularly I know the council have come back in terms of employment use and what it means. I note that response, and it seems to suggest that basically it means anything. This policy is going to cover anything that creates employment. I mean, given it's so wide-ranging, do you consider it would be helpful just to set that out somewhere, maybe in the supporting text at least, so that people are clear what it's covering?
So certainly, we've obviously got the glossary, which includes some definitions of employment sites and uses, and I think it may be more helpful to users of the plan. So we've got a definition of employment land needs assessment, we've got a definition of employment land supply assessment, but we haven't, as it were, got a definition of either employment land or employment uses, and it may be that that would be perhaps the most helpful place to provide it, rather than simply inserting it into a sentence of the supporting text. But as I say, we're not precious about that, but that's perhaps what we would think is a preference.
Yeah, I'd be happy if it was in the glossary. I think it's just helpful to have it explained exactly what's going to be covered when you say employment development, really. And Mr. Short, I know Artisan have explained, raised some concerns with part 3 of the policy. I wondered if you could briefly set those out.
Yes, thank you. Essentially, we weren't clear on reading it what it actually is seeking to do, because as it is drafted in front of me, it's a change of use to small-scale employment use. Predominantly residential curtilage is supported where, and it lists the 3 criteria. So the first query is really what does that mean? What is it seeking to achieve? What's the small-scale employment use? Where is it seeking to encourage that or support that, given that it refers to residential curtilage? Other queries as well. I don't know if you want me to do them all now or take them in turn.
Yeah, if you can raise them all now, then I can go back, get the council to.
Yeah, given that it seeks to encourage small scale, which perhaps is a matter of planning judgment on a case-by-case basis in any event, but in terms of it does not involve significant noise, dust, fumes, or other emissions, etc. That to me sounds like the need for a series of specialist technical reports, which, if we're looking at small-scale employment in perhaps a residential area, is that not going to be self-defeating in the terms of, well, it's a small-scale site, small-scale employment use, but you have to go to the extent of all these specialist reports before you can even get your planning permission. And just wondered if that was what the policy is seeking to do, because it's as I say, it's not particularly clear. And in terms of who's going to want to be put to the expense of all those reports if it's just a small-scale operation to begin with.
Thank you. Would the council like to just come back on those? I mean, particularly, I mean, is that first sentence, should it say within predominantly residential curtilages? Is that what it's?
Yes, there is certainly something missing from that phraseology, and within a predominantly residential curtilage would hopefully make that point clear. In relation to the reference to environmental impacts in criterion D, the extent to which it would be necessary to submit technical reports would, I think, depend on what the activity was that was being considered, because there will be some activities which might be likely to generate noise. There may be others that wouldn't be likely to generate noise. So, for example, if one was dealing with something which involved something to do with, let's say, pet grooming or animals, then there may be an issue about noise disturbance to neighbouring properties. If something was an activity which, let's say, involved treatment of humans, I don't know, some kind of beautician treatment, then you might not expect particular noise. So I think it's a question of it would need to be applied proportionately depending on what was proposed. But if a particular activity was likely to give rise to environmental impacts, then it's not really an answer to say they don't need to be assessed because it will be expensive to assess them. So that's the overall point. But perhaps I'll just ask Ms. Candler to come in on what we're actually driving at with this policy and what type of small-scale employment uses we see as being subject to it.
Thank you. In terms of the district, we've got a lot of examples where we've had uses which have started up within residential curtilages across the area, and particularly across the wider rural economy. And traditionally, without this type of policy, what we tend to have is those uses which will start to operate and it is classed as residential use. And it almost gets to that tipping point where the use may be completely acceptable, but in a lot of instances, there hasn't been a policy mechanism almost to legitimise the use. And then the only option is almost a heavy hand of enforcement on them. That's not residential use per se, but actually we're accepting in line with the NPPF. It is appropriate in a lot of instances that we can have that mix of employment use within residential. So we're trying to create a clear and consistent framework to enable that to happen and to be assessed. So there's a mechanism for that whole sector of the economy to operate, and where necessary to have planning permission. A lot of road uses will exist completely under the requirement for planning permission, but we're trying to give a consistent basis to enable that, so it isn't just the uses either operate classed as residential or they breach that and it suddenly could become an enforcement issue. It's to give that clear and fair approach to all. And as Mr. Bedford said, it may be hairdressers, it may be dog groomers, it could be, there could be endless types of business, but that's the intent of the policy, is to enable and support that type of the economy.
No, thank you, that's helpful. And it's also been suggested in 1A that the wording should be changed to have no adverse impact rather than be sensitive to. Do you have any comments on that and whether you think that's necessary for soundness?
I think, Madam, bear in mind yesterday's discussion, we've already sort of taken away an action to look at policies generally to achieve more consistent treatment between different phraseologies. And whilst certainly we don't think that the term sensitive to is inappropriate, as part of that review of a consistent approach, I think we ought to look at whether there are circumstances where that's the best phraseology, or I say a different phraseology is better, but it will really be wrapped up as part of that, as opposed to is there anything inherently inappropriate about that particular language? We don't think there is, but I say it may be that more in terms of consistency and therefore effectiveness, it'll be part of that process.
Yeah, that's. I don't particularly have any other questions on LP12, but I notice some other people have got some questions. Mr. Short, you want to come in?
Yeah, just briefly following up on the clarification on part 3. That was very helpful to understand the context which that was supposed to be applied, so thank you for that. The only query I have now is perhaps going to be caught up in the general review of phraseology, but the suggestion now is that it should read within a predominantly residential curtilage, and I don't know if that's supposed to be a predominantly residential area. What constitutes a predominantly residential area as opposed to a non-predominantly residential area? What if it's supposed to be curtilage? What's the difference between residential curtilage and predominantly residential curtilage? So I don't know if that's going to be picked up in the overall sort of review of phraseology, or if there is a distinction that I'm not understanding.
I think the intention is to recognise that, particularly in, as it were, diverse rural areas, things don't always fall into neat pigeonholes. And so clearly, if you've got an exclusively residential curtilage, then that would be subject to the part 3. But there could be circumstances where within what is a single curtilage, there might be some non-residential element, but nonetheless, taken as a whole, you would describe it as a predominantly residential curtilage. So it's really just to capture that nuance. And I say there will be a whole variety of different circumstances when one takes into account. I say you may get a residential property and there's a small workshop in the grounds and so on and so forth.
Thank you. Mr. Short, does that kind of answer your query? Does that help clarify things?
Yes, I think it does. Thank you.
Thank you. Mrs. Valden?
Thank you. I'm looking at LP12 1G. It says have good highway access. Well, to what? What sort of highway? What's good? What's not good? It's a little bit vague, and it's sort of. I wondered if that needs to be more in line with NPPF guidelines or something. It just seems, yeah, have good highway guidance access. Sorry, it seems a little. And yes, it goes on to say, and not severe impact. So I just wondered what they mean by highway and what's good, and does that need to be clarified?
Would the council just like to respond on that point?
I think we think that the word is adequate for its purpose. It would embrace considerations of highway safety. It would embrace considerations of highway capacity, and it would embrace consideration of catering for all road users, i.e. Pedestrians, cyclists, as well as vehicle users. No doubt there are different words that you could use, but we think it's sufficiently clear. So we don't see it as necessary to make a change to that word.
Is there anything else you want to say, Mrs. Fowden, on that, or are you?
Well, I mean, it may be clear to the council, but it's not clear to me. So, and I look at plenty of planning applications in my role as a clerk, and good highway access. I just wonder how officers may be able to interpret that as far as employment sites are. But I defer to the council and their knowledge on that then.
Well, it was something I'll give consideration to as well when I'm looking at it, to see whether I consider it's
Thank you.
So is there anything else anyone wants to raise on LP12? Right, we'll move on to LP13. Now, it's been suggested by a number that the policy isn't flexible enough to deal with changing economic circumstances. I just wondered what the council's views on that, and whether why they consider it would be flexible enough to deal with situations like that.
Okay, perhaps if I start, and then Mrs. Candler can comment on any particular issues. Well, we do consider that the policy is sufficiently flexible. It is clearly concerned to provide a level of protection, first of all, to existing economic activity. That's clearly effectively the first paragraph is reflecting the agent of change principle, so that that which is approved shouldn't compromise existing activities. So far as paragraph 2 is concerned, whilst it's obviously got a role in seeking to safeguard existing employment sites, it does recognise that there can be changes away from that, provided that there is adequate consideration given to the justification for that change, including the factors set out in A and B. So it's not a bar on movement away, but it does present tests that have to be undertaken. And criterion 3 again is setting out, I say it's not a bar on relocations, but it is setting out criteria that need to be considered in order to allow those relocations. We think it gets the balance right between having a level of control but not having prohibitions. So then if Ms. Candler wants to come in on it, no, I don't think there are any further points. Thank you.
Is there anything any of the participants want to raise in terms of that? Mrs. Travers-Healy?
Oh, thank you, ma'am. Mine was just in relation to, I think, what we were discussing earlier, really. I think part 3 requires, if there is a partial loss, even though it's deemed acceptable in principle. So I'm quite confused on that aspect. If it's gone through part 2 and it's been deemed acceptable, then you require a contribution. But notwithstanding, I think we raised concerns earlier on when Mr. Bedford cited that contributions if a land swap wasn't available, that there was an SPD that had worked that out. So I think I share concerns of others about the practicalities of this policy.
Yes, I mean, obviously we've discussed, I mean, there's an overlap between part 3 and what we were discussing in LPO 5, which I mean obviously not SPO 5. So I mean obviously the links to that, which so we have discussed. Mr. Cook, you want to come in as well?
Thank you, Mark. Only briefly, and again, noting we're not talking about specific sites, but if there were to be a site that may be allocated in this plan, just to ensure that that doesn't get caught by part 2 and part 3 of this policy regarding 6 months marketing, etc.
Right, yes. Yeah, and whether it, I mean, I was going to ask, is it, again, can we clarify, does this apply to employment sites that are allocated for other uses in this plan, or is it not? Can the council just clarify that?
It's not the intention to apply this policy to the plan's own allocations, because so in a sense, in principle, the position is that those allocations are thought to be appropriate, and therefore there's not a need to, as it were, go through the exercise again in order to justify the allocation. But if we haven't made that clear, then we can look at adding some text, probably to the supporting text, to clarify that.
Yeah, I mean, I think that'd be helpful. I mean, I say it's something we picked up in SPO 5 too, so I think we just need to get the links between that and this policy, and make sure that it is clear, because I think we said we were going to make it clear in SPO 5 that it only applied to windfall, so potentially need to do that here as well. Lady Hart. You're on mute still, Lady Hart.
So sorry. I'm obviously not forceful enough when I tap that button. In the existing plan, the core strategy, there are 2 tests that an applicant has to pass. A marketing campaign, which is retained in here, but there is wording in the existing policy, which is EM24, that the applicant has to demonstrate that the land, the site or the premises are inherently unsuitable or not viable for all forms of employment related use. And inherently unsuitable is referred to in the justification in paragraph 1406. And it says it doesn't mean that the premises is inherently unsuitable, but then that wording's not picked up in the policy. So it appears that the council has decided to make it easier for an applicant to change, to lose employment land. And I wondered if the council could explain why they've altered that policy, please.
So it's altered from the existing, is that the Baber core strategy?
Yes.
It's got that in. So with the council,
we think Chiltern Parish Council consider it weakening the safeguarding of economic land.
So you think there should be more in terms of making it very clear that it's not that this land isn't viable,
or putting the wording that before there were 2 aspects that an applicant has to satisfy, not just that the applicant demonstrates by their own, they're not marking their own homework really, which is what 2 seems to envisage. And we also thought for a larger site, a marketing campaign of 6 months wasn't enough. It should be longer, 12 months possibly. But we think the wording in policy EM24 should be reinstated in this policy.
Could the would the council like to explain and say, say why whether they consider it addresses the kind of like those issues and like the 6 months and 12 months and marketing?
Yes, we think we've got the balance right. It certainly isn't a question of an applicant, as it were, marking their own homework, to use Lady Hart's colourful expression. First of all, any marketing has to be subject to that of an independent qualified assessor. And then secondly, the approach to the marketing campaign must be agreed by the development management case officer from the outset. So clearly it's got to be a fit for purpose exercise. And also in terms of the criterion 2A, it talks about the possibility of reusing or redeveloping the land for other commercial, employment, business or community uses have been explored by a period of sustained marketing for 6 months, etc. So that requires you to consider not merely whatever may be the current use of the premises or its last use. It requires you to consider the full range of uses. As I think Lady Hart has noted, the paragraph 14.06 does, in the descriptor, make the point that where a business is unable to make premises work viably, this doesn't mean that the premise is inherently unsuitable for employment use, as an alternative operator or another business may be able to operate successfully from the premises. So that's the, as it were, the substance, but that's a descriptive paragraph, and we think that the formulation in LP 13.2a is a more precise way of showing applicants what they will need to do to demonstrate acceptability than simply putting into the policy a statement that they need to show it's inherently unsuitable for employment use, which will then lead to questions, well, how do we do that? What are we expected to show? Clearly, by requiring marketing for the full range of potential employment uses for what we consider to be a reasonable period of time, the market will identify what opportunities and solutions there may be, and that will then allow a judgment to be formed.
And what was the basis for the 6 months marketing period? Was rather than say the 12 months or?
But Mrs. Candler as to why 6 months?
Thank you. That was through consultation, and we obviously had views that came in through the consultation process. Some saying it should be a lesser period, some saying a greater. And again, we felt that on balance, 6 months was a reasonable period.
Thank you. Do you want to come back, Lady Hart, on that?
Yes, please. Because Mr. Bedford didn't answer the question about why have you altered the policy and weakened it? I know you said, well, we think it's balanced, but why have you dropped the wording that you already have in the core strategy? If you want to safeguard employment opportunities, why have you dropped that wording and weakened it? There must have been some reasoning to decide that you were going to, albeit refer to it in the descriptor, but not carry it through in the policy.
Well, I think I did answer the question.
Yeah.
In terms of, we think that it provides more clarity to applicants to let them know what they actually have to do to achieve the objectives of the policy, by providing, I say, more specific guidance on what is necessary. As to the point as to, well, you've changed something from a previous plan, 2 points. First of all, each plan isn't, as it were, beholden to the plan before. It is a replacement, and we are entitled and justified in formulating our policies so that they're fit for purpose in terms of what we see as the current circumstances, rather than simply carrying forward previous language. And secondly, since the earlier core strategy, there has been a significant change in terms of the operation of the range of permitted uses. Class E has come in, the guidance in the NPPF has been updated, and we think that we've captured, as it were, the issues by including a range of commercial, employment, business and community uses, which previously I suspect would not have been considered something that would have been within the context of an employment safeguarding policy, because prior to Class E, you wouldn't have necessarily lumped community uses together with employment uses.
I fully appreciate that a new plan doesn't have to reflect what's in the previous plan, but the parish council, we've seen a marketing, this similar wording was in the past, is in the existing plan, the core strategy about marketing. Chiltern Parish Council have got actual experience of seeing this in practice, and it's usually an estate agent hired by the applicant puts forward a fairly subjective evaluation of the site, which is why I used marking their own homework. Is an independent qualified assessor meant to be somebody else, or is it the applicant's appointee?
I think I'd like to. I've got the gist of what your issues, Lady Hart. I don't want to get bogged down in the detailed wording. Now, I mean, I think I understand what this, the policy is. I will have a look at it and consider it and take into light what you've, the kind of comments you said both now and in your written statements, and consider whether I think this is adequate.
Thank you.
Thank you. Mr. Short.
Thank you. A couple of points I just want to go through, if I may. Firstly, along the same sort of lines, is that the suitability of the site for continued employment use, which is under EM24 presently, I do agree with Lady Harton that it should be carried forward into this policy. If you can do a qualitative assessment of the site and you can see that the constraints are such that the possibility of reusing or redeveloping the land for one of the other uses is such that it is not possible to do so, why should an applicant then be subjected to do a 6-month marketing exercise, which it's almost inevitable what the outcome is going to be? I know you don't want to go through site specifics, but we do have exactly that situation now. The other questions I have are, if you are looking to conduct a land swap, are you still expected to go through the marketing exercise? If you're under part 3 of the policy, do you still have to satisfy the requirements of part 2? And finally, I don't know if this is back to the issue of terminology and phraseology, etc., but given the council's response in its hearing statement as the definition of employment use, it's really the issue of if there's a distinction between business, commercial and employment activity and commercial employment, business uses, etc. in the policy. Obviously, community uses is clearly different. Thank you.
Thank you. Would the council like to respond to those points?
Thank you, Madam. On the first point, we think it would water down the policy to simply have a expectation that a qualitative assessment was sufficient, because in a sense the inventiveness of those who make commercial decisions knows no bounds, and whilst somebody might look at a building and take the view that in qualitative terms it has various deficiencies which mean that it isn't suitable. Somebody with, as a business or commercial or entrepreneurial endeavours may say, well, never mind that, I'm prepared to take it on and this is what I want to do with it. That is something that you only know if you expose the premises to the market to see whether there is market interest, and that allows, I say, the full sort of range of interest to be captured. Whereas if it was simply to be the subject of a report saying, well, I don't think this particular building is suited to further employment use, that would, we think, be a weakening of the policy. As to the second point, which is how do criteria 2 and criteria 3 work together? Are they intended to deal with different issues, or are they intended to deal with both? I think I'll just ask Ms. Candler to comment on what the intention was.
Thank you. The intention of Part 2 and Part 3 are slightly different within the policy. Part 2 concerns itself with the loss of employment land. So it would be assuming in that case it would be a use vacating the employment land. The intent of Part 3 is to deal with relocation. Now that may deal with vacating an employment site and moving to another site, for example, within the district. And we have a number of instances where this has been the case over the years. Using one example, which we've touched on the subject this morning, in the whole poultry industry, we've had sites in the past, and we've had one, for example, a poultry site on the edge of a hamlet. The use has relocated to a strategic employment site, and without a policy mechanism to look at the impact of relocation, it simply has left a vacant site with no need for review. And that site has been a large former employment site on the edge of a hamlet, which has automatically become vacant and then become a housing site on the edge of a hamlet. And we're talking about large areas of sites in some instances. What we're attempting to capture with Part 3 of the policy is where we have proposals and are seeking to relocate. We wouldn't be anticipating, as part of a relocation of a business, that they'd be undertaking marketing to prove it's inherently unsuitable. By the very nature of them relocating, they're looking to another plot and to move for their business needs, etc. So we'd be seeking to capture some where they're relocating. If it's in part, for example, in a business is downsizing, a mechanism to capture that and look at the impacts of that on our employment land supply. So the policy isn't intended to be sequenced as such, where you'd need to do the marketing and then look to relocate. They are two subtly but different elements to the policy.
So on that basis, if in Part 2 a site was shown that it wasn't viable and there was no need for the land of the building, it wouldn't be subject to Part 3.
No.
Right, yeah. And then I think so you've answered Part 1 and 2 of Mr. Short's questions. Is there anything on Part 3? What the third point he raised?
Sorry, I'm just double checking back in my notes. I thought that was, apologies, but I thought that element was about the relocation and the sequencing. I may have missed part of the question. My apologies.
Mr. Short, do you just want to come back? Is that answered?
It was the only other query I had was in relation to the terminology used.
Oh, of course, sorry.
You've got business, commercial and employment. I just wondered, given the council's response to what the definition of employment use was in the hearing statement, whether there is still a distinction such it needs all the words, or if I've perhaps missed something.
There isn't a distinction as such. All the words are in there, and as Mr. Bedford's touched upon, to look at when we're looking at alternative businesses, for example, to show it's the full wide range. And this was written in between a transitional period with use class changes going through, so we're trying to capture all of the relevant aspects, but that would obviously be picked up with the glossary and the terminology.
Mr. Knowles, thank you for being patient. You want to contribute something?
Thank you, Ma'am. It was a general point and then a specific. The I mean, it's a very difficult balance because these sites come forward and they do require different marketing. So it is very difficult for the council to put in a policy that covers all eventualities. But I think what they've done is quite a good attempt. I would question, though, the last sentence on item 2, which is the approach for the marketing campaign must be agreed by the development management case officer from the outset. I question, I mean, the skills of development management are not in marketing. And therefore, I don't understand how development management are going to assess the criteria other than going back to the independent qualified marketing assessor, which seems to be the logical thing to do. I can see what the council are saying, and I don't know whether they want to consider that or possibly put in somebody like economic development. It's just queer how a development management are going to come to a conclusion.
Does the council want to respond on that?
I think we would want to see it as being a development management decision to ensure that the marketing campaign was fit for purpose and wasn't, as it were, some kind of box ticking exercise that wasn't really trying to capture market interest. I think the appropriate person to refer to would be, I suppose you could simply say it must be agreed by the council, would be, in a sense, a more neutral term. No doubt, if the development management case officer considered that he didn't have the requisite expertise to take a view, he may well engage in consultation, including with the economic development officer or similar. But that's probably sort of micromanagement in terms of the policy. It may be simpler, rather than specifying a particular person, to simply say must be agreed by the council.
Yeah. Mr. Short?
Just on that point, is how does the council see this working? Are they expecting each and every applicant to submit a request for pre-application advice, or will it be a case that we can go and ask the question a little bit more informally? I mean, how do they envisage this working in practice?
Would the council want to respond then?
Sorry, I was struggling to unmute, Chair. My apologies. This is similar, albeit the process, the wording of the policy is slightly changed. It's similar to the process which we operate currently, both in Baber and Mid Suffolk. And generally, pre-app is a route which such queries go through. That's the established mechanism which we tend to have such discussions through.
Thank you. Lady Hart?
I was just going to add in response to the last questioner's question, that this is the process that it's gone through, that a planning officer is involved in it. The only thing there's no public involvement though at that stage. It's done internally within Baber. So you're presented with, certainly on the example that Chiltern Parish Council saw recently, which is under the existing policy, was a tick box exercise, and we didn't think it'd been done in order to, satisfy what the applicant wanted to achieve, which was to change from economic land to residential. So I would support it being a development manager officer rather than it going just generally to the council.
Yeah, thank you for that comment. I'll bear it in mind when I look at that. Well, I think I've got everything I need to know on LP 13. So unless there's anything anyone else wants to raise, we'll move on. Right. So if we turn to the retail policies now, which is SPO 6 and LP 14. Now I'd just like to start off that in the schedule on the back of your Matter 6 hearing statement, I think you say that you suggest an AM or an MM to correct the errors in terms of removing town centres without boundaries and the reference to the primary frontages. That would need to be a main modification, not an additional modification. It's not appeared yet in the schedule of changes, so that is something that needs to be picked up. But I would like just to, right, I mean, obviously, why is it considered that these town centres shouldn't be defined, particularly as two of the three are defined as market towns in the settlement hierarchy, so they do have a role in providing retail and leisure services to the wider area. I just wondered why you think they shouldn't be defined.
I think I'll turn to Mrs. Candler first to provide an update on the council's thinking.
Thank you. The boundaries as proposed are based upon our retail evidence. So I believe that's EC01, our town centre and retail study. And we were following through the recommendations in that study in terms of looking at the applied town centre boundaries to be put forward.
So although they're identified as market towns, you don't think the boundary, there's any need to define the boundaries?
We haven't defined them, or we didn't consider it was necessary in terms of the JLP. However, some of the neighbourhood plans coming forward, such as the I neighbourhood plan, which is now made, some of the neighbourhood plans have chose to identify their town centre boundaries in those areas. So I and Needham are both proposed their town centre boundaries through that process.
So that's it. They are defined in the neighbourhood plan.
Yes.
So obviously that then becomes part of the development plan anyway. So, right. Okay. Mr. Cook, you want to raise something?
I do, yes, but since Ms. Candler has just said that, I'm scrambling for my I neighbourhood plan to check, because I didn't think that I does have a town centre boundary, but I'll stand to be corrected on that. But I didn't think it did. It has a settlement boundary, as far as I can see, but not a town centre boundary. So yeah, sorry, that caught me off guard slightly, that statement. Anyway, notwithstanding that, yeah, just to support what you've just sort of raised, really, Ma'am, in that I can't quite understand why those settlements wouldn't have town centre boundaries when, as you've already identified, Stowmarket, etc., in the same tier of the settlement hierarchy do have town centre boundaries defined. And Ms. Candler has just referred to document EC01, which is the Carter Jonas town centre and retail study, and the fact that that doesn't make those recommendations. But what I would say in regard to that document, Ma'am, is that it's dated September 2015, and that's well in advance of the preparation of the plan we're discussing, and even before issues and options consultation took place. So before there was a local plan strategy in place, including distribution of growth, etc. And what I would say, in particular for a settlement such as there are 600 or so dwellings now allocated to I across various sites, etc. That retail study has not considered the impact on and the retail needs on. And I mean, previously, I mean, it's just been mentioned that the core strategy that allocates I as having a town centre boundary, and we would support that being carried forward. And just to be clear, I'm not suggesting that it's necessarily drawn larger or expanded upon, but I think it warrants being carried forward because it then allows, the positive. It supports the businesses that remain in I town centre, and this is in the context of paragraph. It was 85, now 86 of the NPPF. Criteria A to F, which are about supporting town centres, and particularly Part B, which requires it includes the phrase defining their extent, and to my mind, you define their extent by drawing town centre boundaries. So yeah, I can't quite understand why they don't, and equally, I can't see if you did draw a boundary, what the harm would be. Like I said, I'm not suggesting it's either expanded upon or, I'm not talking about carte blanche here. I think it's as a positive tool, a positive planning tool. I can't see why you wouldn't impose one.
Thank you. Ms. Chandler, you want to come back?
Thank you. Yes, if I may just provide clarification, I refer to town centre boundaries. I should have explained what it was with the district shopping area boundary. It's what the neighbourhood plans have carried forward, and that's been a carryover from the old local plans. So that Needham, Debenham and I, and our neighbourhood plans have carried over the district shopping area boundary.
So there's district shop. So is that different? I mean, is that different to the town centre? Does it have a different role?
In the previous policy context, it would have had a different role. The study looked at when we looked at, and that was when we were looking at percentages of retail frontages, etc. So it was a different policy format than what we're working in now. But the neighbourhood plans have carried forward what they've defined as their district shopping area boundary.
Right. And are those 3 neighbourhood plans? They're made now, are they? They are.
Sorry, if I can just come in to answer that. So yeah, so the I and the Debenham neighbourhood plans are made. The I neighbourhood plan is awaiting a referendum date at the moment, but yeah, we expect that to progress towards a referendum. Yeah, so that's.
Is it Needham Market?
Needham Market, yeah. Sorry, yeah. Sorry for.
Sorry, but yeah.
Oh, sorry. I'm just being told that the Needham Market one has been made.
Oh, that.
I's been made. Sorry. I has been.
I
made.
And Debenham are made.
Debenham has been made. Yeah.
Needham Market is the one that's.
It's the one that's awaiting referendum.
Right.
Apologies for that.
So I mean, do you consider those to be? I mean, obviously, because paragraph 86 of the NPPF does say that you should define the extent of town centres and primary shopping frontages. I mean, do you consider those district shopping areas to be the town centre boundaries? And obviously, it does say you should define the primary shopping areas too, which isn't being done in any of your shopping areas. What's your response to that in terms of what the NPPF says?
Myself. Right, sorry. I think we've taken the view that given the nature of those relatively small town centre boundaries, i.e. the areas that's encompassed within them, that also reflects the primary shopping areas, so that we don't think that there's a need for a separate delineation of a primary shopping area within the town centre. Obviously, there are elsewhere much larger settlements where a town centre boundary can be quite extensive, and the primary shopping area is a subset of that. But we think, given the nature of these particular town centres, that the town centre is effectively coterminous with the primary shopping area. So we were content not to have them separately delineated.
Yeah, and I understand that, and it might be worth just clarifying that somewhere in the supporting text. And are you saying that you're happy that the kind of district shopping area boundaries that are in the neighbourhood plans are sufficient, are what you would count as the town centre boundaries in those? I'm just conscious that, I mean, like, if you, without any boundaries, any retail development within those centres would need to pass the sequential test. So, I mean, are you, you know, would you use that district shopping area boundary to be the town centre boundary, or would they be required to go through a sequential test, any retail development in there?
I think that's probably a point we just want to take away and just reflect on, because whilst one can see that there may be circumstances where one wouldn't want to apply a sequential test to development within what was in reality a centre, even if it wasn't defined in the local plan, but it was defined in the neighbourhood plan. Equally, one also wants to avoid the situation that, in a sense, a relatively small centre is treated as if it were a town centre, and then it says, well, there are no sites available within that centre, and that therefore justifies edge of or out of centre development in that location, when it wouldn't realistically justify it if you didn't have a centre there, as it were, to start with. So I think rather than sort of respond now, if it's acceptable to you, Madam, I think we perhaps just want to reflect on that and see whether there are any, as it were, disadvantages in terms of retaining the health of those centres in, as it were, cross-referring to the boundaries that are coming forward in the neighbourhood plans.
Right. Yeah, that'd be fine. Mr. Cook.
Thanks, Ma'am. Again, I know we're not talking about specific sites, but not to beat about the bush, the sites that I've referred to again today, LA020, has a retail allocation on it, a small local shop, and that's come from the neighbourhood plan. My line of inquiry really, Ma'am, is to avoid having to do a sequential assessment for something that's allocated. It's not in the town centre boundary or the district shopping boundary or whatever we're calling it in the I neighbourhood plan. It's not quite adjacent to it. I mean, it's a stone's throw away, but again, it comes down to how you define adjacent. But yeah, my line of inquiry is to avoid having to do a sequential assessment for something that's allocated. And if that is, it requires some sort of clarification through this policy, policy LP14, then that would be fine. I'd be happy with that.
Could the council respond on that? I mean, I would say I don't want to get, but just in the principle of how that would operate.
Again, I think in terms of the point being made, that is one of the implications we want to just reflect on, to make sure that we, I say, get it right, rather than, I say, just responding on the hoof. So we'll take that away if I say that's acceptable.
Right. Yeah. Mrs. Travers-Healy.
Thank you, Ma'am. It's just a point. It was interesting to hear the sort of approach around primary frontages and secondary frontages, actually. But on that point, on LP14, Part 2A says that to maintain the vitality and viability of town centres, proposals that include above the shop homes will be, as well as other uses, will be encouraged. Now, I could understand if that was said, you know, within primary frontages and secondary frontages, because as we've discussed, the council have gone with an approach of town centres, which are actually larger and wider, particularly in the council's Sudbury and Stowmarket, that actually that above the shop homes is quite prescriptive, and that actually we should be going with the NPPF phrase of just housing, which I think is at paragraph 86 if I've got my revised NPPF paragraph numbers right, but that was just my point.
Thank you. Is there anything the council want to say on that kind of point?
I think we've taken the view that there isn't a particular value in seeking to define primary and secondary retail frontages, given the breadth of changes of use that can come forward under Class E in relation to premises. I think as a consequence, I think we've already identified I think there's a reference, isn't there, in paragraph 1410 to primary frontages, which is redundant. But I think we think that there is sufficient encouragement for residential through parts 1 and 2 of LP14, and obviously there are permitted development rights which also apply or may apply to particular premises, and we think that is as it were, a balanced approach.
Thank you. Mrs. Travers-Hill, is there anything you want to say in response to that, or?
Well, I would just say that, you know, Part A is quite specific. It says above the shop homes. So I can imagine a proposal coming forward that was not an above the shop home, but in accordance with paragraph 86 of the NPPF, that under this policy would potentially conflict. So I do think there is the necessity there to bring that policy in line and consistent with the NPPF.
Right. So I will look at that and consider that. There's also, whilst we're just on terminology, I think in SPO 6 it talks in part 2 of retail and town centre uses. The NPPF calls them main town centre uses, and we do need to pick that up and just reflect the terminology of the NPPF. I have got a couple of other things I need to pick up on, but we're fast approaching 1 o'clock, and so although it's not brilliant, I think we should break now before I go on to those and finish that off, and then the leisure policies when we come back at 2 o'clock. So we'll break for lunch now. We'll come back at 2 and just remind everyone to switch their cameras and microphones off before they leave. Thank you very much. Good afternoon, everyone. It's now 2 o'clock, and so I'm resuming this hearing session. I'd like to return to our consideration of policy SP06, which we were dealing with before the lunch break. And I would like to just pick up a comment that Stowmarket Town Council have made about suggesting that the town centre in Stowmarket should be enlarged to cover the area around the train station. And I just wondered what the council felt about that and how they decided on the boundary for Stowmarket.
Mrs. Candour to respond on the specifics. I think she's just checking what the retail study had identified, and presumably also to consider to what extent there have been any physical changes of circumstance in terms of town centre type provision since the retail study that might justify any different treatment.
Yes, if I can answer that one. So in terms of the drawings of the town centre boundaries, that has stemmed from the retail assessments, so the town centre and retail study, which is in the core document reference Eco 1. It doesn't contain a map per se, but what it does is sort of describes where those locations should be. So we've drawn the boundaries in accordance with the recommendations set out there. But there's no map per se in that. That's in, but within the plan that is set out in, I believe, one of the appendix to the plan.
It's Appendix 04.
Thank you.
So has any consideration been, I mean, as to the area around the train station? I mean, I that's not somewhere I've been to visit yet. It will be somewhere I go and look at. But and as Mr. Bedford has there been kind of any changes since that 2015 study that might merit changes?
Thank you, if I may. There wasn't consideration in terms of the train station itself in the retail study. The retail study sets out, it's focused at the time on the primary shopping frontages and secondary shopping frontages, and identified a number of streets that would look at. So the basis of the retail study was conducted in terms of that concentration of retail, rather than looking at encapsulating transportation uses and so on, or the train station into that. It's focused on where the main shopping centres are.
Right. So you wouldn't consider that there's merit in changing it to include that train station area?
Not in terms of the town centre boundary. No, we're confident that we're comfortable if the evidence is put forward through ECO1 that would be an appropriate boundary.
Thank you. I mean, it would be something I'd go and look at, but because obviously I don't know that relationship that well, but thank you for your comments.
Whilst obviously you, as you say, you'll look on the ground, but it would look to be a somewhat isolated location. If you look in Appendix 04 to the Stowmarket town centre plan, and obviously you've got to orientate it in landscape to put it north-south, as it were, but you should be able to see the railway line on the northeast of the town centre, shown with, as it were, fairly solid dark lines, and you can see the word navigation approach, which is where there is a road over the railway line, and then it goes off the plan to the north of Stow Upland Street, and the station lying somewhat to the north of that. It would be a somewhat, I say, sort of isolated or satellite location to broaden the town centre boundary out to embrace. I'm afraid you can't see it on that plan, but it's, I say, it's north of what's shown on that plan. So, but obviously it's a matter you can assess for yourself on the ground.
Yeah, thank you very much. I also wanted to just ask, in terms of, I'm conscious that some of the particularly core villages are going to be taking quite a significant amount of new residential development, and I just wondered what kind of, like, in terms of retail, what might be appropriate outside the defined centres, you know, to in some of those villages where, you know, is it anticipated that there might be more retail development needed in those to support that kind of level? Are you just leaving it to the market, or how would it be determined what's in those areas?
Candler's going to respond on that.
Thank you. Apologies for the delay. I was just looking up the correct policy. We believe that around the core villages and other such centres, we have policy LP31, which covers services and facilities within the community, looking at, and it includes both provision of new facilities as well as it does looking at loss of facilities and so on. And we feel that proposals for retail and other wider community use and all such uses would be dealt with within the parameters of that policy.
Thank you. And just the final question I've got in terms of SPO6 and LP14 is in terms of obviously you've referred back to relying on your retail study from 2015 quite a lot. I noticed that says that the impact assessment should be set at 400 square metres. Where the plan has changed that to the NPPF kind of level of 2,500 square metres. I just wondered why you've done that. Have you got evidence to support that change?
Thank you. We took account of representations received through the different consultations in the local plan, and again we had consultations which came in saying the threshold should be higher, the threshold should be lower. And looking at the position of our evidence, we took the view that we actually felt the NPPF, in this instance looking at national policy now, would be the most appropriate because we had very different views coming through the consultation process on that.
Right, so you felt that the retail study was wrong in suggesting 400 then?
Not so much in wrong, but given we had very different views through the consultation, we took the view that we felt the national position would be the more robust position to take for the plan going forward, the NPPF default.
Right. So that's all I've got to ask. Is there, in terms of those things, I think I've got everything I need to make my considerations. Is there anything else anyone else wants to raise before we move on to the tourism policies? No? Right. So this is looking at SPO7, LP15 and LP16. And I've only got a couple of questions really. Well, in fact, one of them is Mrs. Traverse Healy. Is she's still with us? Yes, Mrs. Traverse Healy. I noticed that Pigeon have expressed some concerns in terms of LP15 and suggested a main modification. I wondered if you could just explain why you think that's necessary for soundness.
Yeah, so it was consistency with the NPPF actually, and under, I think it's, let me just find my correct reference. Sorry. It was under 82, basically Part D, paragraph 82, Part D, which allowed for new and flexible working practices. And we just thought with that policy that a modification to allow sort of accommodation to be brought forward where it would assist with the viability of that business and sort of enable new flexible working practices. So that was our rationale for that.
So kind of a tourist development, kind of business development that might need residential.
Yeah, but we made it very clear kind of as it would assist the viability of that business. So, you know, associated with that development, that leisure development.
Right, yeah. Have the council got views on that and whether?
Yes, certainly. If my understanding is correct, we'd be talking about residential use in areas where we'd have tourism accommodation to make the tourism use viable. I think we tend to look at it the other way around. It would want to be looking at the merits of the tourism proposal in itself rather than it justified in terms of residential development to support it. The area would have to be suitable for residential in the first instance. That, as a general rule, I'd think we wouldn't look to that as a principle. I think there may be particular cases where that would be of relevance, but rather than have a policy approach that would automatically support that, I think that would perhaps be looked at as a departure basis rather than a principle underpinning the tourism policy.
Right, yeah. And presumably, would you use it, paragraph 80 of the NPPF as a kind of the framework to judge it?
Absolutely, yes.
Right. And it's also been suggested that there should be within this section a policy kind of addressing second and holiday homes. Is that an issue, a particular issue you think you have in those in the districts and that or that needs to be picked up at all?
We don't consider it as there are obviously second and holiday homes across the district, but not to a point where we feel we would need a particular planning policy to address that.
Right, yeah. So how do you generally just deal with them?
They're just part of the housing demand.
Right, yeah. Is there anything any of the other participants wish to raise on the tourism policies at all? Because I haven't got any further questions on those. So I think we've got a very brief afternoon session. So on that basis, no one else has got anything they want to add. That's all we need to do for today. Thank you all very much for your contributions. I will consider a lot of what's been said and come back to the council in due course with anything that we haven't already arranged if I feel there's anything necessary. But thank you very much. I shall see some of you again next week, I think, or maybe later on in the proceedings. But thank you very much.